Thank you very much, and good morning, everyone. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission. The meeting will be held via conference call in accordance with the agency's implementation of social distancing due to the COVID-19 or coronavirus pandemic. I'd like to welcome members of the public and market participants who are on the phone or streaming this meeting through our website or YouTube channel. There are three different ways you can listen to this open meeting. Number one, by the telephone. Number two, by our own website. And three, via YouTube. So if at any point during this open meeting, one of those systems appears not to work, you have two others, alternatives to listen in on. I'd also like to welcome my fellow commissioners who are also participating via conference call. Commissioner Quintens, Commissioner Benham, Commissioner Stump, and Commissioner Berkovitz. We assembled today to consider two matters. First, a final rule addressing the cross-border application of the registration thresholds and certain requirements applicable to swap dealers and major swap participants. And second, an amendment order exempting certain multilateral and organized trading facilities authorized within the European Union from the requirement to register with the CFTC as swap execution facilities. We'll start, as usual, with the Pledge of Allegiance. I'll lead, but everyone is welcome to join. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'll now move to opening statements in order of seniority. I don't have any formal statements, a formal opening statement for today. I just wanted to say a few words to provide some context. First, I think it's really important that we acknowledge that this is the 14th open meeting that the Commission has had since September. So 14 meetings in less than a year. Everyone on this commission, all of my fellow commissioners, their staffs, as well as the overall staff of the CFTC, have worked incredibly hard. This commission has worked on some of the toughest and most controversial issues that are facing the CFTC and the markets we regulate. And I want to acknowledge that regardless of whether we agree or disagree on certain points, everyone is working extremely hard, and we're tackling those issues that need to be tackled, and in some cases, have been around for several years. And it's really important that I acknowledge all of the work of my fellow commissioners and their staffs and the entire staff of the CFTC. Yesterday, it was suggested that if you were to apply for the first time ever a rule regulating something, but that rule was not as restrictive as something that had been proposed but never finalized, that was a form of deregulation. Well, I disagree with that, and in fact, I was thinking about it, and if you take that logic to its conclusion, that would mean that the Dodd-Frank Act itself is a deregulatory measure, because the original versions of the Dodd-Frank Act that were proposed were more restrictive than that which finally got passed by Congress. So I don't think anyone would say that the Dodd-Frank Act was a deregulatory measure. That said, I want to be clear about something, and that's that if something is deregulatory, I am more than happy to acknowledge it as such. We could say that today's rules are not deregulatory in any way because we didn't have binding rules, that this is the first time we have a binding rule regarding the application of our rules extraterritorially. But I value intellectual honesty, and the fact of the matter is the guidance that has been out there for a number of years now, and the no action letters have been effectively complied with. So what we're doing today is, in fact, a measure of deregulation, and we wouldn't be doing that if we didn't think it was justified. A number of reasons justifying it. Number one, focus on actual risks posed to the United States, deference to foreign regulators, the fact that our world has changed in the years since then, and a variety of other reasons, the substance of which we'll tackle today. What I thought I would say today on the cross-border guidance that we are, in fact, revisiting are two things. First of all, at the time, the cross-border guidance was, in fact, viewed as very assertive, as the Financial Times said the other day, in fact, aggressive. Now, that's just not my view, but in fact, that is the view of many at the time, particularly our foreign counterparts. It was the view expressed by the finance ministers of the UK, France, Japan, the European Commission, by our colleagues at the Australian Securities and Investments Commission, the Hong Kong Monetary Authority, the Monetary Authority of Singapore, the Reserve Bank of Australia, and also the Securities and Futures Commission of Hong Kong, and also the European Securities and Markets Authority. My own personal view is I'm not going to get into whether or not it was necessary or unnecessary, but I think the important takeaway is that this was guidance. It was not a final rule, and by our predecessors making it guidance, it was very clear that they wanted future commissions to revisit this issue in the years ahead. And in fact, in 2016, there was a proposal to revisit it, and now, of course, we're revisiting it today. So I think that's an important point, that the Commission had always contemplated that we revisit it. They knew it was a tough issue, and they also wanted to ensure that we took into account what was going on in the world around us. And that is the context in which we approach this rule today. I look very much forward to discussing this with my colleagues, hearing the views of staff, and ultimately a vote on this final rule. Thank you very much. That ends my opening comments, and I'm happy to now turn to Commissioner Quinten.
Thank you, Mr. Chairman. This is Commissioner Quinten. I hadn't planned on making an opening statement, but I am going to, and it's along the lines of what you discussed. Yesterday, I think, was a historic day for the Commission. We finalized a very important policy, in my view, a thoughtfully constructed, thoroughly aired and vetted and appropriately calibrated swap dealer capital rule, which the market had been waiting for certainty on for 10 years. But yesterday, in my view, also marked a pretty disappointing departure from the level of discourse that this particular Commission has had over policy disagreements during our tenure. Again, in my view, absolutely absurd theories, commentary, language, labels, accusations were thrown around with no substantiated evidence or examples, when in fact quite a few examples, if not all of the policy evidence, was to the contrary. Like you said, Mr. Chairman, we heard an idea that any final rule could be called, quote unquote, deregulatory if it didn't meet the same level of a previously proposed or even suggested regulatory obligation. I think you're right to describe Dodd-Frank, therefore, as deregulatory. It would also be correct to say that under that standard, the most absurd and punitive proposal that was ever put forward with zero chance of becoming finalized would therefore make anything after it deregulatory. And while that theory may fit some people's preferred political narratives, it doesn't hold up to reality or rational thought. Going further into the theater of the absurd, we heard a lot about how yesterday and today's rules will, quote, roll back protections or threaten progress. Yet we only heard broad platitudes, at one point invoking a severe and, in my view, naive view of the cause of the financial crisis as to what these rules may return us to, but again, heard no specific instances of why existing policy was more protective than what we were trying to finalize, which would then substantiate the word rollback or threaten. We heard that last December's cross-border proposal, which we're finalizing today, quote, discarded the existing guidance. But yet last December, we heard that the proposal mostly embraced the prior guidance. I'm fascinated to learn today which one of those it is. Yesterday, we heard objections on APA grounds to going final on a capital rule that had been commented on 3 different occasions over the last 10 years with 200 comments and ex parte meetings received. But yet we have heard crickets on why it isn't appropriate to replace an overly broad guidance issued without any public comment that has reached across the globe and had the effect of regulation for years with a final rule that follows APA procedures. Yesterday, we heard a complete misquote of the statutory language, twisted supposedly for convenience. The language of 2I in the CEA was read as saying, quote, a direct and significant connection to activities in or effect on U.S. market, end quote. When in fact, the language reads, quote, a direct and significant connection to activities in or effect on commerce of the United States. A significant effect on commerce of the United States is much different than a significant effect on any market within the United States. But I'm starting to think that it shouldn't be a surprise that in throwing around unsupported and unsubstantiated political labels yesterday, the language of the actual statute was changed to fit a political narrative. Mr. Chairman, we are better than that. My colleagues are better than that, and this commission deserves better than that. I'm looking forward to a better dialogue today. Thank you.
Thank you, Commissioner Quintens. Commissioner Benham.
Good morning, Mr. Chairman, and good morning, everyone who's able to join us on this second meeting in consecutive days. Look forward to the discussion. I do want to take a second to thank the staff from DSIO. A lot of work has been going on, obviously, in the past few weeks with yesterday's capital rule and then today's important cross-border rule. So I want to applaud Josh Sterling and his team, different team here today on the cross-border rule. This week, as I noted yesterday, is an important week, 10 years since Dodd-Frank, and the cross-border rule is a critically important element of the crisis and what we experienced in 2008, obviously, given the risk that was brought to the U.S. from overseas. And as we consider this final rule today, it's important to contemplate what we've been through, where we've come from, and where we're going forward. So I look forward to the discussion, have a lot of questions, and look forward to the team's presentation. Thank you, Mr. Chairman.
Thank you very much, Commissioner Benham. Commissioner Stone.
Thank you, Mr. Chairman, and thanks again to the DSIO team. You guys have been in the hot seat several times over the course of the past few months, but today is certainly expected to be monumental, and we're very appreciative to you all for all of the efforts. As the chairman has already pointed out, we are today replacing commission guidance with binding and enforceable rules, as was expected by our predecessors, and for that reason, transitioning to binding and enforceable rules, those rules must be clear, sensible, and workable. I believe the final rules before us today meet that standard and are largely the same as that which we proposed. But based upon the public input, we are providing some clarifications that were requested by market participants. And in a few places where the proposal deviated from the guidance, we have actually been persuaded that the guidance got it right and thus are returning to the guidance approach. And in still other places, we're incorporating suggestions made by commenters. I do not plan to summarize here all the changes the proposal is making that are simply for those who are not steeped in the minutiae of de minimis swap dealer registration calculations and entity and transaction level requirements under the guidance. Such a summary might become a bit mind-numbing, but instead I would like to take just a few minutes to talk about the rulemaking in the context of today and explain my support for the broader perspective. And I will begin, as we must always begin, with the terms of the statute. And I want to talk a little bit about Section 2I, which Commissioner Quintens has already raised. Section 2I of the Commodity Exchange Act, which was added by the Dodd-Frank Act, by the way, limits the international reach of the CFTC swap regulation. It affirmatively states that they shall not apply to activities outside the United States unless those activities have a direct and significant connection with activities in or effects on commerce of the United States. A common sense reading of this section is that there is a limited extraterritorial reach to the Dodd-Frank swap requirements. and to stretch them beyond the stated statutory criteria and permissibly infringes upon the rule set of other nations. Some other nations had not yet implemented their reforms when the guidance was put into place, but that's not the case today. So the plainly stated congressional intent is to start with U.S. law not applying beyond our borders, and then to continue to the limited conditions where extraterritoriality would be deemed appropriate. The law does not say that CFTC rules govern derivatives markets activities around the world if there is any linkage or tie to the United States, and should not be interpreted as such. Though this is my view, the correct reading of the statute and adopting rules setting out how we will apply Section 2I to the registration thresholds and regulatory requirements relevant to the cross-border activities of swap dealers. We are not writing from a blank canvas today. The guidance has been in place for 7 years, and although it's non-binding, market participants, as the chairman has pointed out, have devoted tremendous amount of time and resources to conform to its complicated contours. Faced with that reality, although I was not a fan of the guidance when it was issued, I agree that it is appropriate to codify the basic elements into the rule sets rather than start from scratch. And that is what the final rule before us today do. The final rules codify many elements of the guidance, while updating a few provisions to reflect current realities and incorporate some improvement based on experience during the intervening years. I just want to mention one example of an area where I think improvements have been made with regard to making the rule a bit clearer. The release accompanying the final rule acknowledges that the definition of guarantee that we are adopting today is narrower than in the guidance. The concept of a guarantee is important in our cross-border rules for swap dealers, in part because a guarantee of a non-U.S. person's swap obligations by a U.S. person can require that the non-U.S. person count the swap towards its dealer registration thresholds with the CFTC. The final rule defines guarantee as an arrangement in which one party to the swap has rights of recourse against a guarantor with respect to its counterparty's obligations under the swap, with rights of recourse meaning a legally enforceable right to collect payments from the guarantor. By contrast, the guidance interpreted a guarantee to also include, and I quote, other formal arrangements that, in view of all the facts and circumstances, support the non-U.S. person's ability to pay or perform its swap obligations with respect to its swaps. Let's think about that for just a moment. When the determination of whether an entity must register with the CFTC depends upon whether the entity or its counterparty's obligations under the swap are guaranteed by a U.S. person, the meaning of the term guarantee cannot be left to a vague, subjective review of all the facts and circumstances. A rule in which non-U.S. persons must try to determine whether the CFTC might subsequently conclude that a particular arrangement satisfies an open-ended definition of guarantee is not a workable rule. By contrast, the definition of a guarantee in the final rule, which is based on concepts of legal recourse and legally enforceable rights to recover, is clear and workable. Some may downplay the importance of workability in the Commission's rulemaking, but no matter how well-intentioned a rule may be, it's not workable. If it's not workable, it can't deliver on its intended purpose. Furthermore, if we expect compliance with our rules, and we most certainly do, then we must first ensure they are clear, sensible, and workable rules. With that, Mr. Chairman, I will reserve the remainder of my comments for the various question and answer sessions later in the day. Thank you for the time, and I appreciate, again, the work of the Division of the Swap Dealer and Intermediary Oversight.
Thank you very much, Commissioner Stump. Commissioner Berkovitz. Commissioner Berkovitz?
Hello?
Yes, Commissioner Berkovitz, we hear you now.
Okay, thank you. Okay, I have a written statement that hopefully will be posted soon. And in that statement, I go into details, and hopefully that will be articulated in the questioning as to my perspective, why this rule is, to use the term, deregulatory. The fact is, Mr. Chairman, you characterize this, and if I am incorrect in this, please correct me. But it was quoted in the Financial Times. You said this rule will pare back our extraterritorial application of our swap dealer regime. Now, pare back, I looked in the dictionary. It means reduce, to pull back, to cut away from. As I take it, and what the rule does, it does not apply CFTC regulations to many of the activities that would have been covered by the guidance. I think that's the intent. That's what you said. Now, I think the other part of your quote in the Financial Times was, I think, the belief of the majority of the Commission today that that is acceptable because these entities, U.S. entities or their affiliates operating overseas, are in some manner, either through prudential regulation or through the specific market regulation of another regulator, adequately regulated to protect the United States. So in the view of the majority today, there is other adequate regulation of these, and Commodity Exchange Act regulation. The regulation under all our laws of the United States is not necessary for those activities. You've described it as paring back. I think it's reducing, and I think it's perfectly appropriate and proper and accurate to say that from the perspective of the Commodity Exchange Act, from our perspective, it's deregulatory. We are not regulating these activities. We're leaving it to somebody else, okay? So go ahead, do your business. If you're prudentially regulated in a foreign country, we're not going to apply the clearing requirement. We're not going to apply the trading requirement. We're not going to apply swap reporting requirements. That may apply under the guidance. I think it's absolutely accurate and fair to say that is deregulatory. You say you've got your reasons for it. You say it's adequately regulated. Okay, that we can discuss that, but I think it's still an accurate characterization that it's deregulatory. So moving beyond that, there was another statement made about a couple statements made about Section 2I that I just want to address. First of all, and Mr. Chairman, you and I have discussed this, the interpretation set forth today on the scope of 2I is essentially as broad, potentially as broad as in the guidance. And I'm pleased about that. And I want to recognize commend the Commission today and the majority for actually adopting, in many respects, not in all respects, there's some that doesn't go quite as far, but essentially the full scope of the extraterritorial reach of 2I and our laws is affirmed today. It doesn't apply it as far as the guidance did, and that's the nub of the issue. There is much more deference for the reasons I just mentioned, a belief in other regulators to capture these risks than was taken in the guidance. And we'll discuss some of those specifics and whether the alternatives that are relied on by the majority today are truly adequate to capture those risks or not. And I think that's a position that reasonable people can differ on, but I very much do strongly differ on it. So the expanse of 2I, what was considered the extragalactic, intergalactic commerce clause, is essentially affirmed today by the Commission's interpretation. And I'm very pleased about that, and I want to express my thanks to the colleagues in OGC who worked on this for a decade now. But I see it essentially as affirming that basic expansive or interpretation, which is, I think, the correct one. Again, though, the Commission today chooses not to apply it as far as the guidance did for considerations of international comedy. The other point I want to make, more minor, but it was stated. 2I, the interpretation, the guidance was put out for comment. There was a lot of controversy at the time over whether follow the APA or not, but we did put the guidance out for comment. That was challenged. The sufficiency of the Commission's action and what it did was challenged in the courts, and the Commission's action was upheld in the court as a non-binding guidance. And again, I thank the OGC litigative team, my successor, Jonathan Marcus and Rob Schwartz, Carrie Prunella and Martin White, who worked on that litigation upholding the Commission's action on 2I then. So it was 2I. What the Commission did back then under 2I was in no way violation of the Administrative Procedure Act. It survived the legal challenge by industry trade groups to that sufficiency of that administrative process. But there's no justification now to criticize it as somehow procedurally defective. The one aspect that the court said the Commission needed to do was to consider cost benefits of the specific applications, which the Commission subsequently did in accordance with the court order. So I look forward to the discussion today, which will include how specifically these paring backs or reductions in CFTC regulations may affect our markets or commerce in the United States, and whether or not there is adequate protection by these alternative regulators, which I believe there is not. So thank you very much, Mr. Chairman.
Thank you very much, Commissioner Berkovitz. And by the way, you have correctly characterized my views on this. As I admitted, as I made clear earlier today, I do view this as, in fact, deregulatory in the sense that we are reducing CFTC rules and jurisdiction, over their overseas application. So I don't think there's any distance, and we may disagree, but I think on my position, you accurately characterized it, and I very much appreciate that.
Thanks.
Yeah, thank you. Now we will move to staff presentations. For each of the items on today's agenda, the staff will make presentations to the Commission. After each staff presentation, the floor will be open for questions and comments from each commissioner. Following the close of discussion, the Commission will vote on the recommendation. All final votes conducted in this public meeting will be recorded votes. The results of the votes approving the issuance of rulemaking documents will be included with those documents in the Federal Register. To facilitate the preparation of approved documents for publication in the Federal Register, I now ask the Commission to grant unanimous consent for staff to make the necessary technical corrections prior to submitting them to the Federal Register.
So moved.
Second.
Thank you very much. At this time, I'd like to invite a staff presentation on the final rule on the cross-border application of the registration thresholds and certain requirements applicable to swap dealers and major swap participants. From the Division of Swap Dealer and Intermediary Oversight, on the phone we have Director Josh Sterling, Chief Counsel Frank Pisanich, Associate Director Rajal Patel, Special Counsel Lauren Bennett, Special Counsel Jacob Shakin, and Special Counsel Owen Coppin. Ladies and gentlemen of our DSIO team, the floor is yours.
Well, good morning, Mr. Chairman and Commissioners. It's Director Joshua Sterling of the Division of Swap Dealer and Intermediary Oversight, or DSIO, to save me a couple breaths. It's a pleasure to be before you again for the second time in as many days. You can tell we've been busy. I'm here today with, as the Chairman notes, several members of the world-class team I have in my division to discuss our final rule on the cross-border application of our swaps requirements. Having taken the capital rule to conclusion yesterday, this final rule today will mark a decisive coda to my division's work on Dodd-Frank. This is an accomplishment of which the whole agency can be proud, those here today and those who came before us. I sure am proud of our whole team in getting it done. You know, we often talk in my division about a smart, effective, and practical approach to overseeing our registrants. This has been demonstrated by our intelligent rule writing, targeted letter relief, our heat map exercise with the swap dealer community, and our continuing strong partnership with the fantastic Division of Enforcement under Director Jamie McDonald and our great colleagues at NFA and the Chicago Mercantile Exchange Regulatory Department, CME. With today's rule, we continue this fine tradition of laying down the 5 building blocks for DSIO. Certainly, those building blocks enable us to pursue the CFTC's mission, vision, and values to the best of our ability. I will be brief because it's critical to our mission of informing the public through this proceeding about how the rule will work. My expert team will do so shortly. But at a high level, here's how we see the rule enhancing our approach to overseeing swap dealers, plus any major swap participants or MSPs that may surface in the future, as there are no such firms currently registered in that capacity with our agency. This final rule is smart because right out of the gate, it builds off the agency's existing cross-border guidance from 2013. As a result, the rule recognizes that firms worldwide have established methods of achieving compliance with our swaps requirements. This approach should minimize the burdens with any changes we make in the final rule compared to the guidance while providing clarity, the core value of the agency, since the final rule is, by its nature, a fixed and certain standard. Effective. The final rule is effective, in my view, for 3 main reasons. First, it empowers swap dealers to achieve compliance based on the well-worn path they've developed under the 2013 guidance. More on that in a minute. Second, the rule seeks to focus our resources on areas where we have judged there's a potential gap in global oversight that could have the kind of adverse effect on U.S. commerce against which Section 2I of our Commodity Exchange Act means to protect. Third, the final rule does not distract the agency from focusing on cross-border activity. For the swaps requirements that the rule covers, we look to where potential risks lie to the United States, rather than relying on the ill-suited proxy of whether particular trades happen to be arranged, negotiated, or executed in the United States. I don't think we would ever recommend to this commission that the proper exercise of extraterritorial power afforded by Congress should depend on whether people here are involved in transactions over there that have all their risks fall outside the United States. Any thought that the United States is so integrated in the fabric of global markets so that any transaction anywhere must affect U.S. commerce or otherwise have been designed to evade our rules would prove too much. If that were true, after all, we wouldn't have had our extraterritorial jurisdiction cabined by Section 2I, and I would add we wouldn't apply it under our interpretation with a healthy dose of international comedy. Of course, we do not take the concept of arranged, negotiated, or executed transactions in America off the table for potential future rulemakings in areas including swaps clearing or swap execution facilities, as the final rule release makes clear. For now, though, my judgment, as reflected in the rule I put before you with my team for your consideration, is that we don't need that concept to make our aspects of Dodd-Frank and the swaps regime work well. I have 7 years of history that would suggest otherwise. Practical. Unlike other potential paths rulemaking could have taken, we are not today seeking to have the Commission reinvent the wheel when it comes to the approach taken in our 2013 guidance. So, in the vernacular, we started from where we are, which is about as practical as you can get. We think it is practical and altogether reasonable and fair to recognize that firms have done a tremendous amount of work to make sure they can follow our guidance. 7 years of work totaling hundreds of millions, billions of dollars in real costs, and thousands upon thousands of hours of personnel time. Well, that ought to buy you something. More to the point, in the 7 years since the guidance was adopted, we have not observed any material gaps in our oversight of the swaps market. During that time, the rest of the world has caught up to us by implementing their own rules and regulations in accordance with the global standards adopted under the G20 Pittsburgh Accord back in 2009. So, as other countries have filled the remaining gaps, so to speak, we're confident that a final rule premised on guidance that worked when there was little else out there compared to today will perform even better now and in the future. Before handing this over to my expert team, I would like to thank the following members of our staff for their exceptional work. From my division, Rajal Patel, who will be speaking with you in a moment, Lauren Bennett, Owen Copon, Jake Chaikin, Frank Pasanich, and Amanda O'Lear. From the Ops General Counsel, I'd also like to thank Laura Badian, Leanne Duffy, Carlene Kim, and Dan Davis. Extremely helpful input there, and certainly the same is true from the Ops Chief Economist, Steve Kane, Gloria Clement, Scott Mixon. Now listen, while everyone I've talked about has done terrific work, I want to single out Lauren Bennett for a moment. Lauren has been detailed to our enforcement division, and that took place several weeks ago. Yet, she's continued to work on the final rule during that time, essentially pulling double duty. That speaks well of her for sure, but it's also representative of both the amazing team we have here at the CFTC and the inspired leadership provided by Frank Pasanich, our terrific chief counsel, because this is his team before us today. Frank has led the team with focus and grace. He's been on these issues for several years, almost a full decade now, and he's delivered under his leadership to your doorstep a wonderful final rule. So having said all that, I will now turn the presentation over to Associate Director Rajal Patel.
Thank you, Josh, and good morning. I'll start by noting that for ease of discussion, given that there are no registered major swap participants, we are focusing this presentation on swap dealers. However, the treatment of what swap positions would need to be included in an MSP's threshold calculations is generally similar to the swap dealer threshold treatment. We will start with a brief discussion of the defined terms. First, as proposed, under the final rule, a U.S. person is defined consistent with the definition of U.S. person adopted by the SEC in the context of its regulations regarding cross-border securities-based swap activities, and largely consistent with the definition of U.S. person in the CFTC's cross-border margin rule. Specifically, a U.S. person is defined as 1, a natural person resident in the United States, 2, a partnership, corporation, trust, investment vehicle, or other legal person organized, incorporated, or established under the laws of the United States for having its principal place of business in the U.S. 3, an account, whether discretionary or non-discretionary, of a U.S. person, or 4, in the state of a decedent who is a resident of the United States at the time of death. The final rule also includes a definition for principal place of business and states that certain international financial institutions, such as the United Nations, would not be included in the definition of U.S. person. We believe that any person designated as a U.S. person under the final rule would also be designated as such under the cross-border margin rule. However, to provide certainty to market participants, the final rule permits time-limited reliance on U.S. person-related representation that were obtained to comply with the cross-border margin rule. Similarly, in response to comments, the final rule also permits reliance on similar representations obtained pursuant to the 2013 guidance. The final rule allows for reliance until the end of 2027 versus the end of 2025 in the proposal. Under the final rule, consistent with the cross-border margin rule, a guarantee is an arrangement pursuant to which one party to a swap has rights of recourse against a guarantor with respect to its counterparty's obligations under the swap. In general, a party to a swap has rights of recourse against a guarantor if the party has a conditional or unconditional legally enforceable right to receive or otherwise collect, in whole or in part, payments from the guarantor with respect to its counterparty's obligations under the swap. Further, based on comments, the final rule states that when a non-U.S. person's counterparty has recourse to a U.S. person for the performance of the non-U.S. person's obligations under a swap By virtue of the U.S. person's unlimited responsibility for the non-U.S. person, such a relationship is interpreted as a guarantee. Lastly, based on comments, the final rule also permits reliance on prior guaranteed related representations in a manner similar to that for U.S. person representations. For ease of understanding, our discussion uses the term guaranteed entity to refer to a non-U.S. person whose swaps are guaranteed by a U.S. person, but only with respect to the swaps that are so guaranteed. In other words, depending on the nature of the trading relationship, a single entity could be a guaranteed entity with respect to some of its swaps, but not others. I'll now turn it over to Owen to discuss the definition of a significant risk subsidiary that is being introduced in this rule.
Thank you, Roger. The concept of a significant risk subsidiary, or an SRS, as set out in this final rule, would apply a risk-based approach to determining which non-U.S. subsidiaries of U.S. parent entities are required to comply with the Commission's swap requirements. SRSs are those entities that raise particular supervisory concerns due to the possible negative impact on their U.S. parent entities and the U.S. financial system. Under the final rule, an entity would be an SRS if, one, it is a subsidiary of a large U.S. parent entity that has more than $50 billion in consolidated total assets, and two, it satisfies a three-part test of whether the entity is a significant subsidiary of its large U.S. parent entity. If a subsidiary is above a given threshold for one of the revenue, asset, or equity capital significance tests, then the subsidiary would meet the definition of a significant subsidiary as to its parent entity. In addition, because the final rule applies a risk-based approach to determining which entities qualify as significant risk subsidiaries, the final rule would also exclude from the definition of an SRS two categories of entities that are already subject to significant regulatory oversight. The first are those entities that are part of U.S. bank holding companies and intermediate holding companies, which are already subject to consolidated supervision and regulation by the Federal Reserve Board. The exclusion for subsidiaries of intermediate holding companies was added to the final rule in response to comments that IHCs are subject to similar prudential regulation as bank holding companies. The second category of entities that would be excluded are those that are subject to capital standards and oversight by their home regulators that are consistent with Basel III and that are subject to margin requirements for uncleared swaps in a jurisdiction that the Commission has found comparable pursuant to a published CFTC margin determination. Such capital and margin standards would adequately address the potential risk that the entity might pose to the U.S. financial system. I will now turn it back to Roger to discuss further definitions and the rules related to counting for registration purposes.
Thanks, Owen. To wrap up the definition discussion, the final rule also defines foreign branch, swap conducted through a foreign branch, U.S. branch, swap booked in a U.S. branch, foreign-based swap, and foreign counterparty. These definitions are included to differentiate foreign and domestic swaps, to determine if swaps need to be counted for registration purposes, and to determine the availability of exceptions and substituted compliance for the Group A, B, and C requirements, which we'll discuss later. Swap dealers would need to consider how they, their counterparties, and their swaps should be categorized under these definitions. For discussion purposes, we also use the term other non-U.S. person to refer to a non-U.S. person that is neither a guaranteed entity nor an SRS. Now we'll turn to what swaps need to be counted for registration purposes. If the operator could please turn to the next slide, or that would be great. Thank you. Under the final rule, a U.S. person would be required to count all of its dealing swaps toward the swap dealer de minimis threshold. With respect to non-U.S. persons, there are three categories of entities: SRSs, guaranteed entities, and other non-U.S. persons. An SRS is required to count all of its dealing swaps towards the threshold. Similarly, a guaranteed entity is also required to count all of its dealing swaps toward the de minimis threshold. An other non-U.S. person must count its dealing swaps in the following situations. First, the other non-U.S. person must count dealing swaps where their counterparty is a U.S. person other than swaps conducted through a foreign branch of a registered swap dealer. Second, the other non-U.S. person must count dealing swaps when the counterparty is a guaranteed entity, except when, 1, the counterparty is registered as a swap dealer, 2, when the counterparty is a guaranteed entity whose swaps are guaranteed by a U.S. person that is a non-financial entity, or 3, as an addition to the final rule based on comments received, except when the other non-U.S. person's counterparty is a guaranteed entity that itself is below the de minimis threshold and is affiliated with a registered swap dealer. Further, other non-U.S. persons are permitted to exclude from their de minimis threshold calculation swaps that are executed anonymously on a registered or exempt SEF, registered DCM or FBOT, and that are subsequently cleared by a registered or exempt clearing organization. Jake will now discuss the classification and exceptions from swap dealer requirements.
Thank you, Roger. Good morning. I will be summarizing the classification of the Group A, Group B, and Group C requirements, and certain exceptions from the Group B and C requirements available to non-U.S. swap dealers and foreign branches of U.S. swap dealers under the final rule. The Group A requirements include 1, Chief Compliance Officer, 2, Risk Management, 3, Swap Data Record Keeping, and 4, Antitrust Considerations requirements. The final rule provides that these requirements would be impractical to apply only to specific transactions or counterparty relationships and are most effective when applied consistently across the entire enterprise. The Group B requirements include 1, swap trading relationship documentation, 2, portfolio reconciliation and compression, 3, trade confirmation, and 4, daily trading records requirements. These requirements relate to risk mitigation and the maintenance of good record keeping and business practices. Unlike the Group A requirements, the final rule provides that the Group B requirements can practically be applied on a bifurcated basis between domestic and foreign transactions or counterparty relationships, and thus do not need to be applied uniformly across an entire enterprise. This allows the Commission to have greater flexibility with respect to the application of these requirements to the swaps of non-U.S. swap dealers and foreign branches of U.S. swap dealers. Finally, the Group C requirements include the Commission's external business conduct requirements, which are broadly speaking designed to enhance counterparty protections by establishing robust requirements regarding swap dealers' conduct with their counterparties. And in a change from the proposed rule, the Commission's requirements relating to the elective segregation of initial margin collateral for uncleared swaps. The final rule provides that these requirements focus on customer protection and have a more attenuated link to, and are therefore distinguishable from, systemic and market-oriented protections in the Group A and Group B requirements. As noted in the final rule, swap dealers, whether or not U.S. persons, are subject to all of the Group A, Group B, and Group C requirements by virtue of their status as Commission registrants. However, recognizing the potentially stronger supervisory interest of foreign regulators with respect to certain foreign swaps and the Group B and C requirements, and in the interest of international comity, the final rule provides certain exceptions from the Group B and C requirements for registered swap dealers. Specifically, the final rule includes the 4 exceptions from the Group B and Group C requirements in the proposed rule that are largely consistent with the guidance, with certain modifications based on comments we received, and 2 additional exceptions. I will start with the exceptions from the Group B requirements in the final rule. Would you please put up slide 5? Thank you. This slide shows the application of the Group B requirements, taking into account the exceptions in the final rule. It also includes a summary of where substituted compliance for the Group B requirements is available under the final rule, as Lauren will discuss shortly. On the exceptions, first, the final rule provides exceptions for certain swaps of non-U.S. swap dealers and foreign branches of a U.S. swap dealer from most of the Group B and C requirements for their anonymous exchange-traded and cleared swaps. Second, an exception from the Group B requirements for certain swaps of non-U.S. swap dealers that are other non-U.S. persons with counterparties that are also other non-U.S. persons, or, in a change from the proposed rule, SRSs that are neither registered swap dealers or major swap participants nor guaranteed entities. We call them SRS end users. Third, a limited exception from the Group B requirements for certain swaps of foreign branches of U.S. swap dealers with other non-U.S. persons, or SRS end users, subject to a 5% quarterly cap. This final rule also excludes swaps with other registered swap dealers or major swap participants. The exception is not available for any applicable Group B requirement for which substituted compliance is available. Fourth, another limited exception, similar to the limited exception for foreign branches, for SRSs and guaranteed entities that are also registered swap dealers, to put them on substantially the same footing as foreign branches for the Group B requirements. As you will see in Table C, The Group B requirements generally apply under the final rule to all swaps except where a non-U.S. swap dealer, that is an other non-U.S. person, enters into a swap with another other non-U.S. person or an SRS end user. Now for the exceptions from the Group C requirements in the final rule. Would you please put up slide 6? Thank you. This slide shows the application of the Group C requirements, taking into account the following 2 exceptions from the Group C requirements in the final rule, and also the exchange traded exception I noted earlier, which applies to the Group C requirements as well as certain of the Group B requirements. First, the final rule provides an exception from the Group C requirements for certain swaps of non-U.S. swap dealers when not booked in a U.S. branch, and foreign branches of a U.S. swap dealer with non-U.S. person or foreign branch counterparties. Second, the final rule provides an exception from the Group C requirements for swaps booked in the U.S. branches of non-U.S. swap dealers with non-U.S. persons that are not guaranteed entities. As you'll see on Table D, under the final rule, the Group C requirements apply to swaps to which a U.S. swap dealer or U.S. person, other than their foreign branches, is a party, and to certain other swaps that are booked in a U.S. branch. Swap dealers that avail themselves of any of these exceptions will be required to comply with the applicable laws of the foreign jurisdiction or jurisdictions to which they are subject, rather than the relevant Group B and Group C requirements for the relevant swaps. However, they would remain subject to the CEA and Commission regulations not covered by the exceptions, including the anti-fraud requirements in Commission Regulation 180.1. My colleague Lauren Bennett will now discuss the final rule's approach to substituted compliance for the Group A and Group B requirements and comparability determination.
Thanks, Jake. Could we go back to the previous slide, please? Thank you. Good morning, Commissioners. The final rule also outlines an approach for substituted compliance for the Group A and Group B requirements that builds upon the Commission's prior cross-border framework. Specifically, the final rule permits a non-U.S. swap dealer to avail itself of substituted compliance with respect to the Group A requirements where the non-U.S. swap dealer is subject to comparable regulation in its home jurisdiction. The final rule also allows a non-U.S. swap dealer or foreign branch of a U.S. swap dealer subject to the terms of the relevant comparability determination to satisfy any applicable Group B requirement for certain swaps with foreign counterparties by complying with the applicable standards of a foreign jurisdiction. Further, based on input from commenters, the final rule permits a non-U.S. swap dealer, subject to the terms of the relevant comparability determination, to satisfy any applicable Group B requirement for any swap booked in a U.S. branch with a foreign counterparty that is neither a foreign branch nor a guaranteed entity by complying with the applicable standards of a foreign jurisdiction. The final rule also establishes a process pursuant to which the Commission will conduct comparability determinations. First, the final rule outlines procedures for initiating comparability determinations, including a provision which allows the Commission to undertake a comparability determination on its own initiative. Second, the final rule lists the information that outside applicants are required to provide in connection with the request for comparability. This information is intended to provide the Commission with a comprehensive understanding of the foreign jurisdiction's relevant swap standards and regulatory goals, including the ways in which they may differ from those of the Commission. Third, the final rule outlines a standard of review pursuant to which the Commission will determine whether a foreign jurisdiction's regulatory standards are comparable to the Group A and Group B requirements. Specifically, the Commission may issue a comparability determination based on its assessment that some or all of the relevant foreign jurisdiction standards would result in outcomes comparable to those of the Commission's corresponding requirements or group of requirements. This standard, which is informed by the Commission's experience in assessing cross-border comparability, is intended to provide a flexible, outcomes-based approach that emphasizes comparable regulatory outcomes over identical regulatory approaches. The final rule does not impact the effectiveness of any existing Commission comparability determinations that were issued consistent with the guidance, which will remain effective pursuant to their terms. Thank you for your attention, and we look forward to answering any questions you may have.
Thank you very much. This is Chairman Tarbert. I want to thank the DSIO team for that excellent presentation, and of course for all of your hard work on this final rule. To begin the Commission's discussion and consideration of this final rulemaking, I'll first entertain a motion to approve the final rule on the cross-border application of the registration thresholds and certain requirements applicable to swap dealers and major swap participants.
So moved.
Second.
Thank you. I'd now like to open the floor for commissioners to ask questions and give statements. For this rule, we're going to have 2 rounds of questions and comments proceeding in order of seniority. So I will start with the first round, and I thought what I would do for this first round is not ask any questions, but rather just portray to the public and explain my views on why I'm going to support today's final rule. And then I will probably ask some questions in the second round after I hear what my fellow commissioners have had to say. So as I mentioned in my opening remarks, the initial cross-border guidance and related staff advisory, when it was issued, met with considerable international discord, not just from market participants operating overseas, but from finance ministries, from fellow regulators, essentially because the concern was that it was in fact duplicative and disruptive to their regime and undercut their own ability to implement the G20 reforms. Well, I'm not going to revisit the decisions of the past and argue whether it was necessary or unnecessary. Far more constructive, I think, is for us to ask whether it is necessary today. And for me, there's but one conclusion. Because nearly all G20 jurisdictions have adopted similar swaps regulations pursuant to the Pittsburgh Accords, I think it's unnecessary for the CFTC to essentially be the world's policeman for all swaps. On this basis, I'm pleased to support the final rule because it provides needed regulatory certainty for the global swaps market, but more importantly, it properly balances protection of our national interests with appropriate deference to our international counterparts. So let me just explain sort of, again, the various reasons why I support today's final rule. First of all, the need for rule-based finality. Obviously, the Commission's 2013 guidance left much to be desired by market participants and our regulatory colleagues overseas. But the action was taken outside the standard rulemaking process under the Administrative Procedures Act, so it was merely quote-unquote guidance that is not technically enforceable. But as I said earlier, the bottom line is market participants as a practical matter have followed it nonetheless. And over time, there's been a patchwork of advisories and no action letters that have supplemented that guidance. So with over almost 7 years of experience, it's time for the Commission to bring finality. Regardless of what you think about the substance of that, I think everyone on this commission agrees that finality through a final rule is something that ought to happen. Second, of course, is the congressional mandate. Most of my fellow commissioners have mentioned the famous provision 2I, and that is where all of our work today essentially derives from. Now, we're calling this the quote-unquote cross-border rule, and in certain respects it is. For example, the rule does address when non-U.S. persons must count dealing with swaps with U.S. persons, including foreign branches of American banks, towards the de minimis threshold. But more fundamentally, however, this rule that we're talking about today answers a basic question. What swap dealing activity outside the United States should trigger CFTC registration and other requirements? Now, to answer this question, we must, of course, turn to 2I. And Section 2I provides that the CEA, the Commodity Exchange Act, our governing statute, does not apply to swaps activities outside the U.S. except in 2 circumstances. So again, it starts with the idea that, as Commissioner Stump said earlier, it's not meant to apply outside the U.S., but it will apply in the following instances, where the activities have a direct and significant connection with activities or effect on commerce of the United States, or where essentially they run afoul of the Commission's rules and regulations that prevent evasion of our Title VII. So Section 2I, in my view, evidences Congress's clear intent for the U.S. swaps regulatory regime to stop at the water's edge, except where foreign activities either are closely and meaningfully related to U.S. markets or where they're essentially vehicles to evade our laws and regulations. I believe the final rule that we're going to vote on today is a level-headed approach to the extraterritorial application of our swap dealer registration regime, and it fully implements the congressional mandate in Section 2I. At the same time, it acknowledges the important role played by the CFTC's domestic and international counterparts in regulating parts of the global swaps markets. In short, the final rule employs neither a full-throated intergalactic commerce clause nor an isolationist mentality. I think it's thoughtful and well-balanced. Now, as I have stated before, I am guided by three additional principles in considering the extent to which the CFTC should make use of our extraterritorial powers. And these three principles are the following. Number one, protect the national interest. Number two, follow Immanuel Kant's categorical imperative. And number three, pursue SEC harmonization where appropriate. So this is an addition. When I decide whether to vote for something dealing with extraterritorial application, these are additional lenses through which I see the issue. So first of all, protect the national interest. Obviously, an important role of the CFTC is to protect and advance the interest of the United States. And of course, Congress provided us with explicit extraterritorial power to safeguard the U.S. financial system where swaps activities are concerned. Now, it's incumbent upon us to guard against risk created outside the United States flowing back into our country. But our focus cannot be on all risk. Congress made this clear in 2I. It would be a markedly poor use of American taxpayer dollars to regulate swaps activities in far-flung lands simply to prevent every risk that might have a nexus to the United States. It would also divert the CFTC from channeling our resources where they matter most, to our own markets and participants. The rule, therefore, focuses on instances where material risks from abroad are most likely to come back to the United States, and where there's nobody but the CFTC responsible for those risks. Hence, guarantees of offshore swaps by U.S. parent companies are counted towards our registration requirements because that risk is effectively underwritten and borne in the United States. The same is true with the concept of significant risk subsidiary, which we'll talk about a little bit later. Ultimately, we're focusing on those things that, again, are within the national interest and where our national interest demands it. Second principle is following Kant's categorical imperative. So as I said when we proposed this rule, I believe cross-border rulemaking should follow the categorical imperative, which famously was, we should act according to the maxim that we wish all other rational people to follow as if it were a universal law. All right, so what I take from this is that we should ourselves, the CFTC, establish a regulatory regime that we believe should be the global convention. So how would this work? Well, first let me explain how it wouldn't work. If we impose our regulations on non-U.S. persons wherever they have a remote nexus to the United States, then we should be willing for all other jurisdictions to do the same. The end result would be absurdity, with everyone trying to regulate everyone else. And the duplicative and overlapping regulations would inevitably lead to fragmentation in the global swaps markets, itself a potential source of systemic risk. Instead, we should adopt a framework that applies CFTC regulations outside the United States only when it addresses one or more important risks to our markets. Furthermore, we should afford comity to other regulators who have adopted comparable regulations, just as we expect them to do for us. This is especially important when we evaluate whether foreign subsidiaries of U.S. parent companies could pose a systemic risk to our financial system. The categorical imperative leads us to an unavoidable result. We should not impose our regulations on the non-U.S. activities of non-U.S. companies in those jurisdictions that have comparable capital and margin regimes to our own, By the same token, when U.S. subsidiaries of foreign companies operate within our borders, we expect them to follow our laws and regulations and not simply comply with the rules from their home country. Charity, it's often said, begins at home. The categorical imperative further compels us to avoid duplicating the work of other American regulators. If a foreign subsidiary of a U.S. financial institution is subject to the consolidated regulation and supervision by the Federal Reserve Board, then we should defer to our own domestic counterparts on questions of dealing activity outside the United States. The Federal Reserve Board has extensive regulatory and supervisory tools to ensure a holding company is prudent in its risk-taking at home and abroad. The CFTC instead should focus on regulating with dealing activity within the United States or with U.S. persons. And then finally, pursuing SEC harmonization where appropriate. And as I've said in connection with the proposal of this rule, I personally, as a lawyer practicing in this field and just as a citizen, find it surreal that the SEC and the CFTC, two federal agencies that regulate similar products pursuant to the same title of the same statute with an explicit mandate to, quote, consult and coordinate with each other, haven't even agreed until today on how to define U.S. person. This failure to coordinate has unnecessarily increased operational and compliance costs for market participants. I'm pleased that this final rule uses the same definition of U.S. person as the SEC's own cross-border rulemaking. To be sure, as my colleagues have said on several occasions, we shouldn't harmonize with the CFTC merely for the sake of harmonization. We should do so only if it's sensible. In the first instance, we must determine whether Congress has asked us explicitly to do something different or implicitly did so by giving us a different statutory mandate. We must also consider whether differences in our respective products or markets warrant a divergent approach. Just as today's final rule takes steps towards harmonization, it also diverges where appropriate. The approach we've taken with respect to A&E transactions is deliberately different than the SEC's. A&E transactions are swap or securities-based swap transactions between two non-U.S. persons that are arranged, negotiated, or executed by their personnel or agents located in the United States, but booked to entities outside America. While some or all of the front-end sales activities takes place in the United States, the financial risk of those transactions resides overseas. Here, key differences in the markets for swaps and securities-based swaps are dispositive. Swaps market is far more global than the securities-based swaps market. While commodities such as gold and oil are traded throughout the world, equity and debt securities trade predominantly in the jurisdictions where they were issued. For this reason, securities-based swaps are inextricably tied to the underlying security, and vice versa. This is particularly the case with single-name credit default swaps, where arranging, negotiating, and execution is typically done in the United States because the underlying reference entity is a U.S. company. More generally, securities-based swaps can affect the price and liquidity of the underlying security. So the SEC has a legitimate interest in regulating transactions in those instruments. By contrast, because commodities are traded globally, there's less of a need for the CFTC to apply its swaps rules to A&E transactions. And there are a number of other reasons why I support this final rule, but those, I think, summarize the key main points. And I just want to, in sum, conclude by saying that the final rule today provides a critical measure of regulatory certainty for the global swaps markets. It's a sensible and principled-based approach, a principled approach, to addressing when foreign transactions should fall within the CFTC's swaps entity registration and related requirements. As President Eisenhower said, the world must learn to work together, or finally it will not work at all. My sincere hope is that our domestic and international counterparts will view this rule as a concrete step toward working together to provide sound regulation to the global swaps markets. Thank you very much. I will reserve my questions for round two, as I mentioned, and I'm happy now to turn to Commissioner Quintens.
Thank you, Mr. Chairman. This is Commissioner Quintens. First, let me fully associate myself with your fantastic statement. Not only did I think you articulate very well the policy rationale for what we are doing today, provided a number of examples that are concrete, factual, well thought through, in accordance with the statute, with congressional intent, with limitations that serve the justification of this policy. But I also think you described the differences between our approach and the SEC in what they do and what their products are and where they're based and how they impact the United States compared to what our product set is and where our products are traded. And let me compliment you on the alignment with the SEC. It's something that I had pushed for. I'm very glad to see that we've finally resolved the embarrassment of only in Washington can two different regulators have different definitions of U.S. persons. I'm glad to see us align there. I think one of us needed to, and I'm glad to see that. Let me also say that I was drawn to the conversation that the opening statements provoked around deregulation and not deregulation. I feel like it's a little bit, it would carry a little bit more credibility today to be able to have that discussion if those terms and labels were not so intellectually dishonestly thrown around yesterday. But it's not enough just to come in and plant a flag today and say, oh, see, today actually is deregulatory, therefore we win, you lose, and this policy is wrong. You know, deregulation is a term that is a construct of Washington, D.C. partisanship politics and to a large degree, a lazy media structure. It is not the concrete argument about why something is good or bad. The concrete arguments about why policy and regulation specifically are appropriate or inappropriate would be, what is the standard we are deregulating to, and what have we deregulated from? Mr. Chairman, I think what we are deregulating from in this instance is a severe duplication and overlapping jurisdiction with foreign and domestic regulators. For someone to describe, our need to duplicate those features as rolling back necessary protections, is not something that I necessarily agree with, and I'm happy to articulate that, and I'm happy to have that debate. Last December, during the discussion of this proposal, we heard that because the proposal defers to the Federal Reserve's unique and congressionally unambiguous consolidated supervisory authority, that somehow the proposal and what we're doing today would weaken oversight and protections. That discussion then ensued further about how the Federal Reserve had dropped the ball in the last crisis, and we, the CFTC, needed to help it do its job now to prevent the next crisis. Well, I find some things interesting about those arguments. First, if the Fed did in fact drop the ball, then that argument would imply that it already had all the tools available to stop the last financial crisis at its disposal. That would seem to directly refute the ensuing accusations that the crisis was a product of a lack of regulatory authority that Dodd-Frank somehow then fixed. Secondly, it implies that Dodd-Frank itself was somehow completely misguided in that, recognizing that failed role of the Federal Reserve, it decided to reward the Federal Reserve with broad new supervisory authorities and powers. Lastly is the duplication argument, that we, the CFTC, need to supervise on a consolidated international basis, as well as in order to prevent the missteps by the Federal Reserve itself. Not only does that argument completely contradict the significant limited statutory directive in 2I that constrains the CFTC's overseas oversight, but it brings to mind to me an old Washington joke. There was a saying that whenever something in life arose that was duplicative of something else, that it had to be the product of the result of the Department of Redundancy Department. For those articulating a view that we need to supervise the Federal Reserve's supervision, or we need to duplicate or exceed a foreign regulator's obligations, welcome to the Commission of Redundancy Commission. Let me also describe what I think is a very important distinction in this rule, which is where that significant test to U.S. commerce comes into play, which invokes what I think Commissioner Stump went through very well, which is the direct obligation and guaranteeing of those obligations by a U.S. parent. You know, yesterday there was a quote, "The cross-border rules we will consider tomorrow will permit U.S. banks and other swap dealers to avoid the CFTC's rules by booking their swaps in overseas affiliates while still placing all of the risk in their U.S. parents." To place all of the risk in a U.S. parent means that the affiliate is guaranteed by the U.S. parent. But that would actually invoke the CFTC's rules under this final rule. The only way an affiliate could place all that risk in the U.S. parent is if the parent was always willing to bail out the affiliate, regardless of if that threatens the parent's solvency. You know, the argument in favor of that outcome is that a company wouldn't want the reputational risk of leaving a non-guaranteed affiliate left to fail. But I'm kind of at a complete loss to understand how it would be better for a parent and its management's reputation to guarantee a failing affiliate's trades that would end up taking down the parent company itself and wiping out all of its shareholders than it would be to make the astute decision, in my mind, to allow a large but isolated and ring-fenced failure to proceed while preserving the parent entity itself. Further, it's important to link that concept with the inter-affiliate clearing exemption rule, which reduces the risk in the context of IRS and CDS that are subject to the clearing requirement by requiring variation margin by all affiliated entities, regardless of guarantees. Let me just quickly ask a few questions before I reserve the balance of my time for my second round. I'd like to ask a question about this final rule's decision to not incorporate a suggestion from commenters. Can DSIO please explain why it decided not to take commenter's suggestion that a U.S. swap dealer not be required to follow the external business conduct standards of the Group C requirements when the counterparty is a non-U.S. person and decides to not opt into receiving such disclosures?
Sure, this is Jake Chaikin. We're the view consistent with the guidance to where a U.S. swap dealer, other than its foreign branch, enters into a swap. The swap is part of the U.S. swap market, and accordingly, the Group C requirements should generally apply fully, regardless of the U.S. person's status of its counterparty. Where a U.S. person is involved in a swap such as that, there's a territorial basis for applying the Dodd-Frank requirements, and we don't see Sections 2I as being applicable to activities outside the U.S. as being implicated. Exceptions to the requirements are made for foreign branches in the interest of international comedy, where the non-U.S. aspect of the transaction raises the interest of foreign regulators, competitive concerns, and access concerns. And also, we believe that generally the final rule is not the appropriate place to make changes to the regulation of the U.S. swap market, as making the Group C requirements an opt-in regime would require changing all the underlying Group C requirements to apply to all covered swaps, rather than creating these limited exceptions for them for certain foreign swaps, as the final rule does.
Okay, thank you for that very thorough, well thought out answer. I appreciate that. I'd also like to ask a question about the decision to incorporate a suggestion from commenters. Can you please explain why we decided to incorporate into the final rule the commenter's suggestion that a U.S. branch of a non-U.S. swap entity not be required to comply with the Group C requirements with respect to a swap opposite a foreign entity that is a SRS, when it would have to comply if the swap were opposite a foreign entity that is U.S. guaranteed?
Sure, this is Jake again. We believe that foreign regulators have a particularly strong interest relative to the Commission in a swap between a U.S. branch of a non-U.S. swap entity and an SRS counterparty with respect to the Group C requirements. As we noted, those relate to counterparty protection rather than risk mitigation, because an SRS counterparty has a limited nexus to the United States as compared to a guaranteed entity.
Okay, thank you, Jake. I really appreciate that. Mr. Chairman, I appreciate the time, and I'll have more in the second round.
Thank you very much, Commissioner Quintens. Commissioner Banham.
Thanks, Mr. Chairman. And before I ask a few questions here in the first round, I do want to recognize and thank again the team, Josh Sterling and Frank, Lauren, Roger, Jake, and Amanda, and Owen as well. And Josh, I appreciate your reference to Lauren doing double duties. That's great, and appreciate her work and her commitment to this rule. Couple questions here for the first round. I just want to talk on a little bit about the SRS, but then get there, I think, in a second, but start to focus on just the larger picture of this rule and how we're, going from, as we've discussed before, guidance to a more prescriptive rule. From your understanding, for anyone on the team that could help answer this question, given the sort of exceptions for non-guaranteed entities and the SRS itself, or as non-SRSs, do you have any expectation that the current number of swap dealers that we have will either be reduced, will grow, after, assuming the commission passes this, the rule is implemented?
Yes, Mr. Commissioner, this is Josh Sterling speaking, and thank you for your kind words and your question. We have no expectation that there will be a significant change in the number of firms registered or deregistered. So we think the rule will not affect that to any great degree. That is our expectation.
Thanks. The $50 billion threshold, which I think Jake spoke about, if you could just kind of talk a little bit more about that, how we landed there. And I know there is, at least to the extent in the preamble, reference about FSOC and their views on the $50 billion threshold for bank entities. Can you elaborate a little bit on how we ended up there and what was the thinking and how, I guess, you feel that it's the appropriate landing spot to act as a dividing line?
Sure. This is Owen, Commissioner Benham. Thanks for that question.
Yeah.
The $50 billion, you're right, it's using or was used in other places. FSOC is one instance. It was used originally in Dodd-Frank when it was passed to identify those institutions where there would be more stringent prudential regulatory standards. A lot of those thresholds have since been increased or done away with to go for more subjective tests. We thought in designing the SRS construct that it was important to have a clear threshold, that since the entities are going to be doing this initial cut at assessing whether they're an SRS, that they should have something clear and objective to measure themselves by for the definition. And we thought that $50 billion was an appropriate and a conservative approach to identifying those institutions that would pose a significant risk to the U.S. financial system.
Okay, thanks, Owen. I appreciate that. I want to talk a little bit about sort of risk versus activities in the context of 2I. And from my reading, 2I is an activities sort of based test. And thinking about the SRS and this creation of this subset or this exemption, I think about the swap dealer definition itself and the fact that Congress created a de minimis exception. And, I made this point now, I think a few years ago when the commission took a vote on the de minimis rule itself, landing at $8 billion for the threshold. If, in my view, Congress would have, within the context of the dealer definition in 2I, Congress decided to put a de minimis threshold specifically for the purpose of, at a very simple level, articulating that you should register as a swap, but if you fall below this particular level, which the, commission will promulgate, which we did eventually, then there's de minimis sort of effect on the marketplace from a risk perspective. Therefore, you do not have to register as a swap dealer. So my question is, was there ever contemplation that Congress would have included something of that nature in 2I? Now, I understand this has been parsed and adjudicated and this sort of discussion around significant connection and then activities and commerce and markets. But, was it ever contemplated by the division that instead of narrowing our, what the guidance has interpreted to mean, what the guidance has interpreted 2I to mean, was it ever considered that, there possibly, like the definition of swap dealer, would have been a more narrow exception to 2I itself, as opposed to what we're doing here in creating the SRS entity with its particular thresholds? I hope that was clear, but I'm just trying to be curious if you guys ever thought about that within the context of the dealer definition and the fact that we have the de minimis exception, but none in 2I.
No, thank you, Mr. Commissioner. This is Josh Sterling. That is, well said. I believe that it was clear, and I understand your question. I'll at least begin our response, but yes, we certainly did give this concept looking at Section 2I and looking at the guidance, a great deal of consideration. And I think we took note of some factual things and trying to evaluate as a policy matter what we ought to do here. And one way of looking at it in 2I is that we're talking about, as you say, activity that would have a significant connection or effect on commerce in the United States. And I'm not reading that verbatim, but the concept is let's look in comparison to commerce. And commerce in the United States, by any I think conventional measure, is quite massive. And so, our thought was, okay, well, within the United States, Congress was clear about a registration threshold for swap dealer. I'm just saying that for comparison's sake. So then, when we get outside the United States, let's take note of the world. And should we try to apply the same standard in isolation here as we would over there? And I think the answer was we need to have a bit of a funneling effect, and that's how we looked at 2I, that we have to think of things relative to U.S. commerce. And so what that standard ought to be, I think, started with the notion of having a large company, and then from there, through many discussions and some fact-finding and analysis, a large company that has a large subsidiary that isn't subject to, as other commissioners have articulated, and the chairman as well, consolidated supervision, right on down the line, and sort of be outside a G20 jurisdiction, because we looked around and we've done, as you know, sir, a number of comparability determinations over the years for a lot of major money market-centered jurisdictions. And so, putting that all together, we tried to come up with a standard that would make sense to say, okay, in this narrower, I should say, it's naturally narrower than everything. Within this subset or this defined space, at what point do we then start applying the $8 billion threshold? And that's how we arrived at it. So we did put a lot of thought into it. We didn't think, it should be, and I know you weren't suggesting this, sir, $8 billion notional for dealer registration should apply equally all over the world. We thought 2I, as a policy matter, wouldn't permit us to do that. I'd invite anyone else from the team to complete the response. If no one, then back to you, sir.
This is Frank Basanich. I just wanted to add, if I understood the question correctly. So, and SRS is by definition, a non-U.S. person, and that non-U.S. person is already required to count all of its swaps with U.S. person guaranteed entities. So there's already an activity, the de minimis already applies to that non-U.S. person. The question is which of these non-U.S. persons that have a relationship to a U.S. parent should have to count all of its swaps, even swaps with non-U.S. persons, toward their de minimis. So there's already an activities-based test there. If that non-U.S. person is doing enough business with the U.S., it'll have to register as a swap dealer. If it's not doing enough business with the U.S. but is doing enough other business, dealing business, the SRS definition will, if they're captured by the SRS definition, they'll have to count their non-U.S. business toward that as well because of the risk-based connection to the U.S.
Thanks, Frank, and thanks, Josh, as well. And, I think I agree with you on the $8 billion point, Josh, that you made, and Frank, I think you followed up. But one thing that I sort of am wondering and questioning, and I think this was the thrust of the question, which you did respond to, is, again, sort of from a congressional intent standpoint, since we have this mark in the swap dealer definition where we have, obviously, an exception for a de minimis threshold. Obviously, we have the IDI.
Commissioner Benham, could you repeat your question? You went out for just a little bit.
Sorry. So I wasn't asking a question, Mr. Chairman. I was just kind of clarifying really what Frank and Josh had said themselves, that I wasn't necessarily suggesting that the $8 billion should apply overseas, but just using the dealer definition as a comparison of, if Congress wanted to create some sort of exception to our authority over 2I, notwithstanding the obviously significant use of the word significant and activities, I feel like there may have been something more there for us to work from, as opposed to what I view as a pretty broad authority across swap dealing activities. want to move to just two more questions in this first round. On the harmonization front, and the chairman, did a great job with the A&E perspective of why we decided to not harmonize with respect to the SEC on A&E because of the security-based swap differences. Is there anything the team wants to add? I think it would be helpful for me and the public as well to explain beyond what the chairman discussed, and then more generally, can you articulate, again, to the extent the chairman didn't, where we did harmonize with the SEC and where we did, obviously with U.S. person, but if there are other elements of our cross-border rule before us today where we were able to find places to harmonize precisely with them.
Yes, Mr. Commissioner, this is Josh Sterling. Thank you for that. I'll take the piece on me. I think the chairman's remarks hit the nail on the head, so I don't think we have anything else to elaborate on there. Of course, we're happy to answer further questions on that, absolutely. And then I'll turn over to the team on other areas of harmonization with the SEC.
So this is Rajal Patel. I'll add that, definition of a guarantee and an interpretation of the guarantee. We've done some harmonization with the SEC's approach as well. And certainly in some of the accounting requirements, not in all of them, but certainly some of the accounting requirements are harmonized with the SEC.
And Rajal, this is Josh. Sorry, just to elaborate. Sorry to interject, Mr. Commissioner.
Yeah.
We did, in fact, consult with the SEC
Right.
on the final rulemaking.
Correct, yes.
Okay, and then on the A&E front, with respect to bookings and the difference between what the chairman articulated, fully agree that the commodity element of the swap dealing is global in nature, much more global in nature than securities-based swaps. But really, the thrust of A&E is that you can, any element of a trade can happen overseas, but if the parent is in the U.S., let's, for obvious reasons, say New York, then any sort of element below a negotiation can take place, regardless of the fact that the trade in many respects is global in nature and happens offshore. From a U.S. perspective, so many elements of the transaction itself could still take place. So where was the debate and the thought process there as we sort of pivoted away from the current action relief and feeling more comfortable with, moving forward with the methodology that we are today?
Yes, sir. This is Commissioner or Director Sterling again. The considerable amount of thought did go into this, and we started with retracing our steps just a bit, because to go back to 2013, arranged, negotiated, executed A&E was not in the guidance. It came through a subsequent staff interpretation that would have taken effect, but was held in abeyance by a no action letter. And I think my judgment is I think it's a better place for the commission to be in addressing things as a rule. Obviously, that's why we're here today, as you know, sir. Setting that aside, the way we thought about it was, our swaps requirements covered by this rule, and only those requirements, which are substantial, pertain to the business of dealing. And if the business of dealing involves the transfer of risk outside the United States, we then would really have to ask ourselves, well, is being present here to discuss the trade, to arrange it, A&E it, I guess, is that enough to sort of say, okay, well, we have to make sure that somehow we're looking towards applying some or all of those requirements to the trade? We didn't think so, for the simple fact that the risks are offshore in terms of exposure on the trade. Now, what I will say is that we did have some really good discussions with the Division of Enforcement about, okay, there are still people in the United States involved in swaps transactions, and we as the CFTC have a strong interest in that. And I think our record is quite good as an agency, and certainly in this division, that we're engaged in a very effective oversight of the swaps markets and the swap dealers themselves. And so our view was, in consultation with enforcement, that if folks in the states were engaged in inappropriate behavior that would affect the market, disrupt it, manipulate it, we would have very many tools available under anti-fraud provisions, anti-manipulation provisions of the Act to get after those people in the full force and effect of the Division of Enforcement to pursue wrongdoing. And that struck us as a good balance. You know, if the risk isn't here of dealing, we're not applying our dealing requirements, including registration. If there's conduct here related to dealing overseas and it is having an adverse effect in our market, then we sort of have, we indeed do have, enforcement tools and surveillance tools available to us. So that was sort of our thinking as a policy matter on the split there, sir.
Thanks, Josh. And last question is about representations. And I know in this final proposal or final language here, we moved, I believe, and correct me if I'm wrong, from 5 to 7 years for representations between counterparties that they're either U.S. persons or not, U.S. person or non-U.S. persons. If that is in fact correct, or I characterized it correct, I think from just as a general matter, and help me understand this better, but a representation, I feel like something like that can get done immediately. We're giving, registrants or participants 7 years to sort of confirm or reaffirm representations about their status within the context of our rules, our new rule. Can you walk me through that and why something on a shorter basis was not, maybe it was considered, but why it wasn't implemented as opposed to going to 7 years? And I know some commenters even went so far as saying, we don't have to reaffirm representation, but would appreciate some thought on, or some ideas on what went into that thinking to get us to 7 and why something shorter wasn't implemented.
Okay, hey, so this is Rajal. I'll start on this one. So we proposed the temporary reliance, and as you noted in the proposal, is 5 years. We proposed temporary reliance on prior representation because, our impression is that SDs and MSPs sometimes somewhat routinely amend their swap trading relationship documentation, and thus updated representations could be obtained in the course of these routine amendments. And, we've also noted that best practice would be to obtain updated representations as soon as practicable, but we wanted to allow the 5-year grace period, given that depending on the structure or the nature of the relationship between certain counterparties, that might not be happening. And we received some comments indicating that the 5-year period might prove problematic for certain types of entities. And so as a measured response to those comments, we extended the period to 7 years in the final rule. But we note that generally best practice would be to obtain updated representations as soon as practicable. And, SEs and MSPs, as I noted, amend their trading relationship documentation on a somewhat routine basis.
Thanks, Rajal. Go ahead, Frank.
Sorry, this is Frank. I just wanted to add that, after the 2013 guidance, in order for swap dealers to classify all of their counterparties correctly in accordance with the definitions in the guidance, is that had to run a industry-wide protocol that took quite a bit of time to get all the counterparties signed up. We recognize that with the change in the definitions under this final rule, that putting a relatively short compliance date on the rule would require, once again, for the industry to, ramp up a large and costly protocol. So in anticipation of getting that comment, I think we proposed the initial 5 years, which some folks told us was either too short or was not necessary at all because they should be able to rely on the representations forever. So it's a medium between having a compliance date, being able to have a compliance date that is about 12 months, and forcing a protocol to be run within that time versus allowing reliance on previous representations over the next 7 years. A protocol still may come into effect, but it won't be done under the gun of 12 months.
Thanks, Frank. Appreciate it, and Rajal as well. Mr. Chairman, that's it for me in this first round. I'll use the second round to read part of my statement. But again, I want to thank the team. And as always, we may not agree on everything, but I do appreciate all the work, the engagement with my office. And of course, you're just, ability to get to this place, a big accomplishment. Thanks, Mr. Chairman.
Thank you very much, Commissioner Benham. Commissioner Stump.
Thank you, Mr. Chairman. I want to start by commending the team for a remarkable presentation on a very complex subject. I think you guys did a really great job of distilling the information in a way that is digestible, and I envision derivatives attorneys across the world screenshotting your charts, and so I want to thank you all for delivering such a great presentation. But saying that, I want to start with some very basic contextual questions. Am I correct that there are over 100 swap dealers currently registered with the CFTC?
Yes, Commissioner Stump. Oh, sorry, Roswell, please go.
No, wait. Yeah, so yes, there are 108 as of this morning.
Okay. And am I also correct that approximately half of them are located outside of the United States?
Correct. Just over half, 61 of the 108.
So to your knowledge, has that percentage on registered swap dealers located outside the United States remained relatively constant at about 50% since the CFTC swap dealer registration requirements took effect?
Yes, to our knowledge, yes.
So for those who have maintained that the final rule takes too narrow a view of the Commission's extraterritoriality with respect to swap dealers, I note the truly remarkable fact that today, with the guidance in effect, approximately half of over 100 swap dealers currently registered with the CFTC are located outside the United States. In other words, although it was non-binding, the Commission's guidance appears to have brought a substantial portion of global swap dealing activity into the Commission's regulatory regime. And, as was noted in response to a question that Commissioner Benham asked, we would not expect to see a significant increase in the number of registered swap dealers if the Commission adopts these final rules, nor would we expect to see a significant number of currently registered swap dealers withdraw their registration if the Commission adopts these final rules today. So in reality, I just want to put this in context. Any paring back, as it's been described, of our cross-border reach still leaves us with the expectation that well over half of the swap dealers registered with the CFTC will be located outside of the United States. That's fair?
Yeah, I think, yeah.
Okay. I just wanted to provide that as some basic context for the reality of what we have today and what we expect in the future. And the fact is that we will continue to have many swap dealers that are registered from outside of the United States that fall within our registration regulatory purview at the CFTC. And so I just didn't want to leave the public with the impression that we are allowing anyone outside of the confines of the United States to avoid registering with the CFTC. So now turning to some more specifics and a little bit more granular, I want to talk a little bit about the significant risk subsidiaries. And I think it's important to talk about this because it is a new concept that was introduced when we proposed these rules and we're carrying it forward in the final rule. But some, in responding, suggested that the definition of significant risk subsidiary inappropriately substitutes the oversight of the Board of Governors of the Federal Reserve System or foreign regulatory authorities for the Commission's regulation of derivatives markets activity. And I just think we need to be clear about what we're talking about here. We're talking about entities that are non-U.S. persons whose swap obligations are not guaranteed by U.S. persons. In other words, if you're a U.S. person, you're going to need to count your swap dealing activity towards the registration threshold for potential CFTC registration. And if you are guaranteed by a legal recourse arrangement by a U.S. person, you're also going to need to count your swap dealing activity towards potentially registering with the CFTC. This significant risk subsidiary category is above and beyond those two elements. And it's not that we're replacing our oversight responsibilities with those of the Federal Reserve Board or a foreign regulator, Rather, it is in that narrow context that we have determined that the risk presented by foreign subsidiaries consolidated with a bank holding company or an intermediary holding company, or subject to regulations as specified in the significant risk subsidiary definition in their home country, is already being adequately monitored, and thus does not warrant an additional layer of regulations by the CFTC, where again, we're referring to those entities that are non-U.S. persons whose swap obligations are not guaranteed by U.S. persons. So to put it in context, we must compare the significant risk subsidiary definition in the final rule to what it replaces in the guidance. A conduit affiliate, that was the term used in the guidance that we are not carrying forward in the final rule. And I'd like to drill down just a little bit on the difference between the conduit affiliate in the guidance and the significant risk subsidiary concept in the final rule. Is it fair to say that both of these are types of entities that are non-U.S. persons whose swap obligations are not guaranteed by U.S. persons, but they have some type of connection to U.S. commerce that causes us to consider whether they should be brought within the CFTC's swap dealer regulations?
Yes, thank you, Commissioner Stump. This is Owen again for the SRS. Yes, in general, that's true. That's an accurate description.
Was the concept of conduit affiliate in the guidance a new concept when it was introduced there, or was it a concept that had previously existed in the Commodity Exchange Act or CFTC regulations in some other context?
I believe it's a new concept for the guidance.
Okay. The guidance did not actually define conduit affiliate. It rather described it in terms of certain factors. As with the definition of guarantee that I already discussed, I think it's important that we have definable metrics, and that's why I support the significant risk subsidiary alternative in the final rule, which is based on objective and observable metrics, as compared to the ambiguous description of conduit affiliate set forth in the guidance. We owe the global swaps market the certainty that can only come from clarity in our rules. And I'm just curious, did any of the commenters in the proposed rule provide any data or information about how many entities that consider themselves to be conduit affiliates under the guidance would fall outside of the definition of significant risk subsidiary?
No, this is Owen again, Commissioner. We didn't receive any data like that in the comments.
Madam Commissioner, it's Josh Sterling. I'm sorry to interject. I just wanted to add in as well from my own personal experience. Prior to joining the commission, I think there's a great deal of uncertainty about what could possibly be the conduit affiliate, so that ties directly to your point on the need to provide clarity and certainty, ma'am.
Right. Thank you for that, Director Sterling. Does anyone from the staff have any reason to believe that the number of entities that consider themselves to be conduit affiliates under the guidance, but that fall outside of the definition of significant risk subsidiary under the final rule will be significant?
This is Owen again. I don't believe we have any reason to believe that.
In terms of what swaps are counted for the swap dealer and the MSP registration calculations, are there any significant differences between the treatment of conduit affiliates in the guidance and significant risk subsidiaries in the final rule?
So this is Roswell. No significant difference.
So the reason I ask all of these questions is because I believe the record before us does not afford any basis on which to conclude that the definition of significant risk subsidiary in the final rule will lead to less robust commission oversight of the cross-border swaps activities of swap dealers than does the vague description of conduit affiliate in the guidance. We have no evidence that the number of non-U.S. entities that have waded through multifaceted conduit affiliate descriptions in the guidance and concluded that they are conduit affiliates, but would conclude that they are not significant risk subsidiaries under the definition of the final rule is significant or even material. If experience going forward proves otherwise, the Commission can always amend the significant risk subsidiary definition accordingly. But absent any evidence, hypothetical concerns are an insufficient basis on which to reject the clear and workable significant risk subsidiary definition in the final rule. I now want to turn to a completely different subject matter, but also one that I think there's been a tremendous amount of confusion, which is arranged, negotiated, and executed. And some have suggested that this is a retreat from the guidance that the Commission has determined not to apply Group A, Group B, and Group C requirements to swaps of non-U.S. swap dealers with a non-U.S. counterparty, where the non-U.S. swap dealer uses personnel or agents in the United States to arrange, negotiate, or execute the swap. I simply disagree. As was pointed out in response to Commissioner Benham's question, the guidance issued by the Commission didn't contain any provisions specifically addressing arranged, negotiated, or executed transactions. So I have a couple of questions. When the Commission issued the proposed border swap dealer rules under Chairman Massett in 2016, did those proposed rules include any provisions requiring that A&E transactions be counted in a swap dealer's de minimis calculation?
No, they did not.
Okay. And would the 2016 proposal have applied Dodd-Frank requirements to A&E transactions?
That proposal only covered external business conduct standards for swap dealers or swap dealer counterparty protections, and it proposed to only apply the anti-fraud and I believe the daily trading records.
Okay, thank you. So I just wanted to be clear that the notion that the CFTC swap regulatory regime should apply to A&E transactions was not stated in the Commission's guidance. Rather, it was stated in a staff advisory published after the guidance was adopted. The Commission has never endorsed that staff view, and it has never taken effect to this point. And so we are not reversing something that didn't have the backing of the Commission, have the endorsement of the Commission in prior iterations of cross-border considerations. And so I'm not suggesting that those who were involved in that at the time didn't have good reason to do so. We were working in very different times at that point, but I am suggesting that never has the Commission endorsed that concept, and so we simply are not rolling that back at this point. And I just wanted to clarify all of that as we move forward with the regulations. I'll stop there, Mr. Chairman. I have several other questions, but I can wait until we reach the second round of questions to ask them. Thank you.
Thank you very much, Commissioner Stump. Commissioner Berkovitz.
Thank you, Mr. Chairman. Before I get into my questions, I just would like to fill in the record on a few comments that have been made previously, provide more context. The first, I'm sorry to have to return to this topic again, but I believe the comment was made, I think, Mr. Chairman, and I don't mean to be too picky about words, but I think that you referred to the guidance as being, quote, outside the APA. And that is exactly what partially the litigation was about, but somehow this guidance was not in accordance with the APA. But one of the holdings of the court in SIFMA v. CFTC, and it's a fundamental principle of administrative law, that an agency has the flexibility to proceed by rulemaking or adjudication. We can issue policy statements. We can issue interpretive guidance. The challenge to the guidance was we didn't follow the APA when we issued the guidance. And let me just read from SIFMA versus CFTC. In the absence of any congressional indication to the contrary, the court concludes that Section 2I operates independently without the need for implementing regulations, and the CFTC is well within its discretion to proceed by case by case adjudications rather than rulemaking. So that's exactly what the guidance indicated we would do. We would do case by case adjudications. And in that context, in the context of administrative law, adjudication doesn't necessarily mean a formal on the record adjudication. It can be an informal adjudication, and informal adjudication can be, just somebody calling up and asking the agency a question even. So that's a flexible term, but I just want to emphasize once again that the guidance was fully in accordance with the Administrative Procedure Act. At the time, in 2013, we were rushing, the agency was rushing to implement the congressional mandate to do all the Dodd-Frank rules within 1 year. And this was 2.5 years later. At the time, many of these thorny questions, which we're discussing here today, this is 10 years after the passage of the Act. We're discussing and debating exactly how far to extend our cross-border jurisdiction, what factors should we consider in pulling somebody in, and how you balance international comity and how much risk. Back then, it was even more uncertain. It was a new regime. The CFTC was struggling with how to apply this overseas, and frankly, we're still in the very in the recession caused by the financial crisis, and there was an urgent need. Congress gave the agency 1 year to put many of these rules into effect to proceed expeditiously. And on a cross-border context, the agency chose to proceed in a manner to provide flexibility and that would not definitively state out positions in an area where the CFTC hadn't regulated before. I know there's a great clamor now for clarity and certainty. We have to define everything. We have to get it absolutely clear right here. The industry can't stand all the uncertainty and the vague terms and the circumstances, the factors and circumstances, tests and considerations. But frankly, we just did a rulemaking. We've just proposed a rule where we took exactly the opposite approach. Let's take the Reg AT issue. In Reg AT, the agency did exactly that. It didn't do exactly that. It did more of that. There was more certainty and clarity. You have to have this, you have to have that. Although it did give flexibility in how you're implementing. And then the cry was, we need flexibility. We can't have all this prescriptivity. So when we're prescriptive, they say we want flexibility. When we get flexibility, they say we want prescriptivity. So to me, the terms of clarity and certainty, they don't necessarily add a whole lot to the debate because they're used, but whatever side doesn't like whatever approach is in effect at the current moment. If it's prescriptive and they don't like the prescriptivity, they say we want flexibility. If it's flexible, but they might not like the outcome under the flexibility, they say we want certainty that flexible outcome indeed won't occur. So it really gets down in the end, not just to providing clarity in regards to the substance. So we'll have a good substantive debate here today. The other thing I want to mention is the harmonization with the SEC issue. The fact is that if my dates are approximately correct, in August 6th, actually a week from, or 2 weeks from now, let me just read you the timeline on the SEC's website. April 6, 2020, effective date for cross-border security-based swap rule amendments. August 6, 2021. August 6, 2021, counting date for thresholds and SDS entity definitions. October 6, 2021, compliance dates for certain rules applicable to SDS entities. Now, I understand the SEC has a lot on their plate, and they have a lot of priorities. And frankly, security-based swap dealers, I think the percentages of swaps versus security-based swaps, I think, based on perhaps notional amount, it's a rough estimate. It's something like we have 95%, they have 5%. It's not to diminish the percent or the task that they have. But the fact is, again, we moved quickly. The CFTC, Mr. Chairman, you talk about being a global leader. We were the global leader. We moved out first in the world and in the United States on the CFTC regulations and implementing the Dodd-Frank Act that we're celebrating the 10-year anniversary of proudly. I think we're all proud of what we've done in those 10 years. And the agency in the world, we were the world leader and moved out to protect the U.S. markets and the U.S. economy. And other folks, it might not have been totally harmonized with the SEC, but the SEC was years behind us. The SEC was years behind us in the implementation of this. And frankly, much of the world was years behind too. And I know, I remember, and there was an outcry at the time, how dare the United States come into our territory and tell us what to do in our markets, et cetera, et cetera. And it was disruptive. But the fact is that we were first out of the box. And it was always intended, and it has worked out that way, that as other jurisdictions come online, we would grant substitutive compliance and we would defer. And we've done that, and we're doing it today. Okay, we're going to do it right after this. And I'm going to support that just like I've supported all of it before. It's not like we're running roughshod over the world and everything applies all the time. We have a balance right now. And the balance has been working, and other jurisdictions have come online. And Mr. Chairman, we're very close to another difficult negotiation completing, and you're involved in that and showing excellent leadership on that, on another international issue regarding regulation of certain entities, and hopefully that will turn out well. And so it's a difficult process, back and forth, and feathers get ruffled and whatever, and we work it out over time. But part of this was that we were first out. Now, we've gained experience over those 10 years, and so I'm not saying we need to continue guidance. I'm fine with codifying some of these now that we've got a lot of experience under our belt. But the question is, what are we going to codify? Codification for codification's sake, clarity for clarity's sake, or a rule versus a guidance just for its own sake isn't the question. The question is, what are we codifying, and whether there's going to be certain objective tests that are going to include or exclude certain activity from our regulatory sphere based on other criteria. So I'm going to go into exactly that issue in my questions right now. But first, I want to just confirm. I'm going to read again. I'm going to read from the release for the benefit of the folks that might not have it, and I'm going to ask about guarantees and conduits affiliates. But I just want to confirm what the Commission is confirming here in the document. In this sense, we're talking about financial groups, global financial entities. A global financial enterprise effectively operates as a single business with a highly integrated network of business lines and services conducted through various branches or effective legal entities that are under the control of the parent entity. Branches and affiliates in a global financial enterprise are highly interdependent, with separate entities in the group provide financial or credit support to each other, such as in the form of a guarantee or the ability to transfer risk through inter-affiliate trades or other offsetting transactions. Even in the absence of an explicit arrangement or guarantee, a parent entity may, for reputational or other reasons, choose to assume the risks incurred by its affiliates, branches, or offices located overseas. Swaps are also traded by an entity in one jurisdiction, but booked and risk managed by affiliate in another jurisdiction. The final rule recognizes that these and similar arrangements, okay, among whatever those are, among global financial enterprises create channels through which swap-related risks can have a direct and significant connection with activities in or effect on commerce of the United States. So just confirming, it's not just the formal guarantees that are defined in the final rule between a non-U.S. affiliate and the U.S. parent, but all sorts of other relationships between that affiliate and the U.S. parent can effectively bring the risk of the swap activities of that affiliate back into the United States. Is that correct?
Mr. Commissioner, this is Director Josh Sterling. Thank you for your question, sir. That is indeed a correct recitation of the language, and we do talk about the transfer of risk. And I would add as a corollary to that, that also implies necessarily the transfer of return. But yes, these are indeed sort of global markets. And
we've talked about conduit affiliates, and one of the criteria for conduit affiliates is back-to-back swaps. And could you just explain that concept of a back-to-back swap between an affiliate and a parent, and why that might be done?
Oh, sure, Mr. Commissioner. Happy to do that. Director Sterling again. Sure. It's almost like, this is I don't mean to oversimplify, but it's not unlike the transitive property in math. So I enter into a trade as an affiliate with a customer. And then I, as the affiliate, may enter into an offsetting trade or a trade that's a transfer to another of my own affiliates. And that could be done for a variety of purposes, for internal risk management, There could be other financial planning or business planning reasons for doing it. There are myriad reasons within the business judgment of companies to do back-to-back transactions, sir.
Okay. But when there is a back-to-back, the risk ultimately would be borne by the U.S. parent. Is that correct?
Well, sir, again, Director Sterling, I think that is true if we're talking about a pure one-to-one transfer of all risks, yes.
Okay, so would a parent, we've talked about guarantees, and it is correct that, or I just want to confirm that the guidance had a broader definition of guarantee, flexible definition of guarantee, and I'll just read again. The commission this is from the guidance, would interpret the term guarantee, generally to include not only traditional guarantees of payment or performance of the related swaps, but also other formal arrangements that, in view of all the facts and circumstances, support the non-U.S. person's ability to pay or perform its swap obligations with respect to its swaps. The commission believes that it's necessary to interpret the term guarantee to include the different financial arrangements and structures that transfer risk directly back to the United States, disregarded as the substance rather than the form of the arrangement. So would a U.S. parent, do you think U.S. parents are aware or knowledgeable of activities of their overseas affiliates that effectively put the parent on the hook for the affiliates transactions? If the CEO of the bank calls in the general counsel and the CFO say, okay, we're doing these swap activities of our affiliate, are we in the U.S. on the hook for those? Can the CFO and the general counsel answer that question of the CEO of the major international bank as to whether the home office is responsible for the affiliates, for paying the affiliates, backing up the affiliate?
Yes, Mr. Commissioner, happy to answer that question, and thank you for it. I would just like to note, as an initial observation, in terms of the definition of guarantee, I think is proposed and final. It's consistent with the guarantee definition in our cross-border margin rule. I just note that for the benefit of the public, sir. To your point, sir, I don't know, and I can only postulate as to what the CEO, general counsel, or CFO of a particular financial institution might know at any given time about anything, including what's on the lunch menu. But to your point, I get it, sir, that is there indeed a transfer of risk in connection with particular trades. What I can tell you is that I have, from my experience, a degree of confidence that our rules exist and operate in such a manner that risks that are material to a banking organization that includes a swap dealer would be knowable. We have a requirement for a risk management program, that's for sure, and if everything is rolling up into a Fed-supervised or banking-supervised financial services organization, there are supervisory requirements and on-site supervisors in many cases that would also be aware of that. And then there are many financial reporting, tax, and other reasons why one would be able to appreciate the size of trades, where the risks lie, and in what manner the risks apply. And I think a corollary to that is sort of a strong understanding of where the risks stop in, for example, the context of bankruptcy and remoteness. So I guess the answer is I think the tools exist to understand and evaluate risk, financial services, in many respects, the business of risk. So I do think, to sum it up, yes.
Yeah. Okay. Yeah. To me, just another predicate here that the final rule that defines guarantee is basically a written document that formal written guarantee that provides recourse to the U.S. parent. Correct.
So this is Roger.
Yep.
You know, in the definition, it's an arrangement pursuant to which one party has rights of recourse against the guarantor, and it's a conditional or unconditional legally enforceable right to receive or collect payments from the guarantor. But we also note that the terms of the guarantee need not be included within the swap documentation or reduced to writing, provided that under the laws of the relevant jurisdiction, the swap counterparty has a conditional or unconditional legally enforceable right. and Part 2C payments.
Thank you. But the reality is it's the language that I read from the preamble states that there are arrangements. There are similar arrangements or risks that the parent may assume the risk, and there may be other arrangements whereby the parent is liable for the risks of the affiliate, even without that specific document that you mentioned, that right of recourse. Correct. That's what I take the preamble states. That it's not just these types of recourse when the parent might be liable for the affiliate's actions. Correct.
Yeah, Mr. Commissioner Sterling again. Thank you for that. Yes, I think that really the rule intends to define what guarantee would mean in the context of what the rule says. I believe the preamble is meant to sort of articulate the context in which we arrived at a guarantee definition that would set the tenor for the rules that flow from it, sir.
So, and the CEO, I mean, to apologize, the CEO of one of these global international banks and the CFO and the bank must know in New York whether what the London branch is doing, so they've got to pay that. I mean, it would seem to me to be if they don't know, if whoever's managing the books of New York doesn't know whether they're on the hook for the swaps of what's going on in London, there's a problem with that bank. I can't believe that prudential regulation or any regulation would permit a bank to operate and not know that the New York office is on the hook for the activities of the London office, right? So they would know whether there's this type of financial arrangement or not, or quote, guarantee. Correct?
Mr. Commissioner, I would like to think that is the case, and I think I take your point, sir, that there ought to be an awareness, given all the rules and the oversight out there, of where the risks lie and who's responsible. I think, obviously, sir, there's also the possibility that a bank could believe that certain risks stop in certain entities that are, for example, bankruptcy remote or not guaranteed on the one hand, but there could be litigation over it where, someone is out some money and thinks that the parent co has deep pockets and ought to pay. So I think there could be a difference of opinion. That's what courts are for and arbitrations are for. But yes, I think fundamentally someone ought to know with a degree of certainty based on legal and financial advice what the risk exposure is.
Great. Yeah, they do risk exposure reports daily. They got to know. I would think. But if they don't, then it's shakier than I would have thought. So the rationale provided, as I understand it, for taking the narrower definition of guarantee and not the definition, not the consideration, facts and circumstances test, the broader test in the guidance, is this, and I'm reading from the preamble, which says a narrower definition. Well, here it again. It says it right again. Let me just read it. The Commission understands that these other the Commission is aware that many other types of financial arrangements or support other than a guarantee as defined in the final rule may be provided by a U.S. person to a non-U.S. person. I'll omit the parentheses of listing them. The Commission understands that these other financial arrangements or support transfer risk directly back to the U.S. financial system with possible adverse effects in a manner similar to a guarantee with a direct recourse to a U.S. person. So it affirms the concern that the guidance was trying to get at. It says that these other things, other than what the rule defines as a guarantee, could transfer risk back to the United States just the same as a guarantee. So there's many ways that risk is coming back, and we just talked about they got to know it. I mean, New York has got to know whether their risk reports daily, whether they're on the risk for the London swaps. However, the Commission has determined that a narrower definition of guarantee than that in the guidance would achieve a more workable framework. Particularly, it says because it's consistent with the cross-border margin rule, but the bank knows whether it's under one rule or the other. They've got to know it. And then it goes on, the Commission is sympathetic to comments regarding and is independently aware of the difficulty in confirming or obtaining representations from counterparties regarding whether certain arrangements, particularly purely internal arrangements within a counterparty's corporate group constitute a guarantee. So the basic problem is they're not telling their counterparties their status and whether they count or don't count swaps, and how that swap is classified is going to depend on whether it meets this definition of guarantee. And they know whether it is or isn't. They have to know whether it is or isn't, and it transfers risk back to the United States just the same. But they won't tell the counterparty, and the counterparty can't get that information, and the counterparty says, we can't get the information. We don't know, because they give it up, and they are guaranteed they're subject to Dodd-Frank. So they're not telling anyone. And we're not making them tell. Oh, it's too difficult. Why is it too difficult to tell? Why is it so difficult for them to tell their counterparties whether there's that guarantee? That's my question. Why is it difficult if they know it? They got to know it. Why can't they tell their counterparty? Why can't the counterparty get a representation whether that swap is guaranteed or not? It's got to, I mean, I would think it's a significant part of the term of the transaction.
Yes. Thank you, Mr. Commissioner, for that question. I'm not sure that we're actually saying that there, or presuming that there is knowledge that the counterparty has that's not shared with counterparty B. I think with the definition of guarantee, we mean to describe a broad set of circumstances in which liability could be transferred to the guarantor, and that's what we mean to give to dealers, let's say, in the form of a final rule, so they themselves can understand what that means, so that they can conduct their businesses appropriately, which is to say there is or there is not a guarantee. So I'm not sure, sir, that I understand that there's a lack of transparency or communication to counterparties. I'm not sure that that's at all encapsulated in our definition or so forth. So you'll forgive me if I'm not getting your point, sir. That's my fault, but I don't think we mean to say that there's. Sorry, sir. Please.
I'm just reading the preamble. The Commission is sympathetic to comments regarding and is independently aware of the difficulty of confirming or obtaining representations from counterparties regarding whether certain arrangements, particularly purely internal arrangements within a counterparty's corporate group, constitute a guarantee. U.S. Bank knows whether it's guaranteeing the affiliate under the broad functional definition, not the technical narrow definition. A broad functional definition in the guidance, they know. They can figure out whether they're on the hook. They have to be able to. A multinational bank can't operate without knowing whether the U.S. parent is liable for its affiliates, whether it's guaranteed or not. They know. And this says, I read this as saying, Commission is sympathetic to comments regarding and is independently aware of the difficulty in confirming or obtaining representation. They won't tell their counterparties. They won't tell their counterparties. It's going to subject, potentially, if they say, yes, we are, it's going to trigger Dodd-Frank requirements for both sides of it. And so, I mean, basically, if you don't want any of this guarantee stuff to apply, you just don't put it in writing. I mean, that's what this is going to. That's what they've already done. That we've seen it happen. They de-guaranteed already. They had formal guarantees and they withdrawn them. And they go through the record and look at what they've done over the years. Because if the trigger for the application of Dodd-Frank is a formal written guarantee, they're not going to do that. But they're guaranteed just the same. So by elevating a form over substance, we're withdrawing from the whole concept that if you're guaranteed, by a U.S. entity, you're going to be subject to all these Dodd-Frank requirements. So, but this says that the problem that we're sympathetic to is they're not telling their counterparties. So that's like, I think that's just discuss the guarantee, the whole guarantee provision here is my view.
Okay. Thank you, sir.
I mean, if you want to respond, I don't want to cut you off, but otherwise I'll go on. So
no, thank you, sir. Please.
So we've been talking about significant risk subsidiaries and how at a certain level, if one of these non-U.S. entities is big enough, according to these metrics in the rule, if the subsidiary is a certain relative to the parent is a certain size, and the parent has got a certain amount of total assets, and then there's exclusions based on whether they're potentially regulated. But is it effectively that for what's captured under the guidance or captured that would have been captured under the guidance under the broad definition of guarantee and the conduit affiliate concept is now intended to be captured by the significant risk subsidiary concept, the entities?
Thank you for that, sir. Director Sterling again. I think I think I can best respond in this way, which is that there's a definition of guarantee and a discussion of factors for conduit affiliate in the guidance. And now we, of course, continue to have a definition of guarantee. Of course, it's different as we just talked about, sir. And then we have this definition of significant risk subsidiary. We don't have conduit affiliate. So I do think we mean for significant risk subsidiary to exist and for conduit affiliate not to exist. And I have to tell you, in candor, based on practical experience, there were real challenges in the market understanding what precisely could be a conduit affiliate, which I was aware of walking in the door here. So I think we tried to come up with a more clear standard, sir, and that would be SRS.
Okay. So again, let me read from the preamble again. In response to Better Markets comment that the SRS definition does not address evasion and avoidance concerns that are addressed by the conduit affiliate concept, the Commission believes that the SRS definition adequately addresses these concerns within a risk-based framework. The Commission believes that to the extent an offshore entity is entering into transactions with non-U.S. entities and subsequently back-to-backing those transactions to a U.S. entity, it is appropriate to subject such an entity to certain of the Commission swap requirements if that entity meets the definition of an SRS and is consequently a significant subsidiary of the U.S. parent entity that is significant to the U.S. financial system. Okay, so it says basically you think they're going to be captured by SRSs. The SRS definition adequately addresses those concerns within a risk-based framework. Correct?
Yes, sir. I think that SRS definition provides more clarity around the kind of non-U.S. entity we think would trigger concerns under 2I if indeed they're dealing.
Well, I somehow, my concern with this is that if SRS is designed to capture this concern, the following statement, which also appears in the cost-benefit considerations, quote, of the 61 non-U.S. SDs that were provisionally registered with the Commission, non-U.S. swap dealers that were provisionally registered with the Commission as of June 2020, the Commission believes that few, if any, will be classified as SRSs pursuant to the final rule. Is that still accurate? Your still assessment? Few, if any? There will be few, if any, SRSs?
So, yes, sir. Thank you for that question. So what we're saying, if I recall that passage correctly, I don't have it immediately in front of me, is that foreign swap dealers are not going to be SRSs. Yes, but in any case, of course, we agree with what's in the final rule, every jot and tittle.
So we set up, we say we're going to address the risks by back-to-backing and affiliate conduits through the concept of an SRS, and we say, well, nobody's going to qualify as an SRS. Probably nobody's going to be an SRS. Fail to see how that structure is going to capture any risk if nobody's going to be in it. I mean, we set up a category of entities to capture risk, and then we put the thresholds in such a way that nobody's in those entities. So what risk are we capturing by?
This is
unaddressed.
Yes, sir. This is. I'm sorry, I cut you off, sir.
No, go ahead. Sorry, go ahead.
Oh no, my apologies. Thank you, sir. So, I think what we mean to say is that there are swap dealers overseas that are registered. They're registered as such. They'll continue to be registered as such, and as much as we expect firms that are registered in the U.S. as dealers will continue to be registered as such. I think that SRS is a new concept. As Commissioner Stump and others observed in our earlier discussion, sir, it provides a fixed standard. We can get into those elements and what we're really trying to look for with it, which I agree. I think it may be somewhat different from conduit affiliate in its direction. We're trying to find 7 years on areas of the world where there are risks we would worry about because they could have this effect on U.S. commerce, let's say. I think one of the challenges, though, with conduit affiliate, and I personally would not be comfortable continuing with the regime that relied on that definition, is that it was indefinite and there was confusion. And I think if you give people a fixed point to start with, and we can talk about the merits of the fixed point, that's a better way to ensure some measure of regulatory protection than a standard that, from what we heard, was vague and wasn't capturing things very well. That's my sense of it anyway, sir.
Well, and that's, I mean, I can understand that. I mean, if you say we're going to create a concept of an SRS, so what the 2016 proposal did, the commission's, to do just that, was create the thing called the foreign consolidated subsidiary, which basically said if you were, a consolidated subsidiary, you were included, and that prompted a significant opposition, and so this is this takes this final rule here recognizes that these foreign consolidated subsidiaries present risk back to the U.S. and then it says, well, we're going to capture, we're going to capture the risks presented by the broad definition of guarantee and the conduit affiliate risks that were addressed in the guidance by the SRS. But it's those criteria. It's the way you've defined what the Commission is defining an SRS in this document. There aren't any entities that meet it, so it doesn't do anything. It's not capturing any risk because there's nobody in the category. I just don't know what the utility of it is if it's an empty set of entities. It's not preventing anything.
Well, Mr. Commissioner, thank you for that. I will respectfully disagree with a starting premise that the definition of SRS will capture no one. The honest truth is, we didn't do an inventory of every company over 50 billion in the United States because eventually we're not going to know what their structures are around the world in great detail. You don't even have to report that if you're a public company in the United States subject to the Securities Exchange Act, periodic reporting there. What I think we're really trying to do is say, okay, it's 2020. And we've had guidance for 7 years. The rest of the G20 jurisdictions have really caught up in terms of their rules to implement the G20 Accords from 2009. We have Fed macroprudential regulation in their rule book. We've made a number of substituted comparability or substituted compliance determinations. And so in this newer, more recent framework, what are we looking for? We're basically looking for a non-bank that's big, that's got a big subsidiary, that is outside a jurisdiction that's a G20 jurisdiction, and is sort of running a material swaps book, and it ought to be registered as a swap dealer. So if it doesn't exist, then it would suggest to me that material swap dealer activity is mostly happening in G20 jurisdictions where we're comfortable there is appropriate oversight. Or it's being done perhaps someplace else, sorry, sir, almost done, where there is Fed supervision. Apologies for extending my response, sir. Please, didn't mean to. No.
I'm actually glad you did. I'm sorry to interrupt. And what you just said is a critical point. So there's nothing that I'm just reading here that our own document. Few, if any, will be SRSs. So what we're relying on is just what you said. We're relying on prudential regulation and the prudential regulators in these non-jurisdictions to capture risk. This is what it does. Let's be clear about it. It relies on prudential regulation in foreign jurisdictions to capture risks that, under the guidance, the CFTC is now capturing. These are non-U.S. affiliates of U.S. swap dealers where the risk resides in the United States, okay, and their swap activity is in the United States. And under the current guidance, they would be, if it's back-to-back to a conduit affiliate or guaranteed by the parent, it's treated like a U.S. person. And we're saying, well, now that's prudentially regulated in some foreign jurisdiction. None of this Dodd-Frank Act stuff applies. We're not doing, it applies just like some other foreign person. And I think that's a hugely fundamental difference and fundamental problem that we're disapplying Dodd-Frank, not even on comparable European market regulations. They have a comparable clearing requirement. They have a comparable trade execution requirement. It's just a prudential requirement, which is a whole new concept that we hadn't done before, deferring to foreign prudential regulators over the swap activity that is the risk is borne in the United States. I think this is, well, let me get, I don't know what the timing is, but this is right on, I prefer to complete this line of questioning rather than wait to another round, so I indulge my colleagues in doing that. So here's the issue in doing that, and in the way this is set up. What is to prevent the U.S. bank from moving its activities into one of these affiliates where it's not subject to any of this stuff and conducting it out of a non-U.S. affiliate rather than the U.S. parent? If it's backed by the U.S. parent and under, you just talked about it, arrange, negotiate, execute, if the parent, if you can do it with your New York people, okay, and the risk and you book it in your foreign affiliate, the risk ultimately resides in New York. You use your foreign affiliate as a sort of an intermediary. It's like back to back or one of these other types of guarantees that they know about, and you conduct it out of your foreign affiliate rather than, and you do it rather than book it directly out of New York. Why can't a U.S. bank just move its stuff over, to its foreign affiliates and therefore avoid all the Dodd-Frank stuff that currently apply to its activities in New York?
Yes, sir. Thank you again for that question. Very, very good point. I think, in my experience, there are many reasons why a bank may elect not to do that. There are tax reasons. There are foreign exchange reasons. There are lifestyle reasons. There are many reasons to go into business decisions to make changes to your corporate structure beyond the Section 2I of the Commodity Exchange Act and this 300-page rule. They're myriad, they're complex, and they can really drive profit and loss and kill or resurrect careers. So I think it's challenging to say that this would lead to a massive offshoring of trading activity. I also think, if I may, that there's always a risk that whenever you provide a certain standard, that there will be people who seek to structure around it. I think that must be true of almost any standard. And respectfully, sir, I think we've tried to say to ourselves, if XYZ America Bank wanted to put its business in the UK, there's a regulator there, France, right on down the line. The picture might look different if XYZ foreign bank, and with all due respect to the Central African Republic, wanted to put its business there, then yes, there we would have a keen interest in regulating that activity. The Fed might do it on a consolidated basis. If it were an energy company doing the same thing, the Fed wouldn't, and we would step in if there's dealing above a de minimis threshold, and our rules would apply. And so I don't mean to be simplistic at all by drawing a comparison or a distinction between the EU on the one hand and the Central African Republic on the other, but I guess that's my point, sir, which is that we're trying to find real dark spots where material business activity would occur, and I'm not sure that there are in the way that I think you might be.
Well, let's not talk about the dark spots. Let's just, for now, that's another topic. Let's just talk about Europe. Do we care? The FTC's perspective, I guess from our perspective, this does permit exactly that. It would permit the New York banks to move operations to London or Frankfurt or whatever if they want, and use these mechanisms, back-to-back swaps or non-recourse guarantees as defined, to retain the risk in New York, to use the New York personnel, okay, but book it in London, but the risk resides in New York. Just move it that way. All future transactions, do your transactions out through that London affiliate. This permits that, correct? It doesn't prevent it, right? And then right? You said there are other reasons, but this does not prevent that. I mean, are you there? Hello? Did I lose it? Hello?
We hear you, Commissioner Berkovich.
Okay.
Josh Sterling, we do not hear you.
In Josh's absence, this is Frank Basanich. I think in that narrow sort of view of things, I guess it is possible, but it has been possible under the guidance for the last 7 years, and we haven't really seen that develop. Folks de-guaranteed to free themselves from the strictures of the guidance. Not doing strictly back-to-back got you out of the conduit affiliate definition under the guidance. And so that structure that you've described has been possible, I think, since 2013, and we haven't really seen it develop.
Well, okay, so, but I just want to be clear on the answer is yes, it's possible. But it is possible under this final rule for the New York banks or wherever they are located in the U.S. to structure their swap transactions with non-U.S. persons by say, well, look, I can either book this out in New York and be subject to all this Dodd-Frank stuff. I book my transactions with non-U.S. persons out in New York and be subject to all these Dodd-Frank transactional requirements and all this stuff. I don't want, my counterparties don't want, but I got to do it because the CFTC tells me to. I don't want that anymore. If I do it out of London, I can still use my guys in New York, still on 7th Avenue or wherever, and they come to work every day. They can do it out of New York. We'll back-to-back it, or I know it's on our books anyway, as my general counsel and CFO tell me every day what my risks from London are. So I'll just, let's do it that way from now on. And that way, all my transactions with non-U.S. persons. I care about that. I guess I'll sort of. I think that's a significant problem. I mean, why would they? And the factors I think that Director Sterling, that Josh, you raised, there are many reasons why not. But one of those reasons why not is not a CFTC reason. We seem to be agnostic. As to whether this rule will allow New York banks, that will permit it. There's other considerations. There's tax and this and that. I don't know. I don't pretend to know about how significant those are. But from our perspective, the fact that New York banks could or are permitted this device to move out into these other jurisdictions and thereby not be treated as U.S. persons when the personnel are in New York, they're U.S. banks, their books are in New York. And so the question there, Mr. Chairman, is the balance. I mean, we talk about a balance, and I think this just goes way, way too far, way off kilter in terms of where this balance between our interests are. We have such a strong interest in the U.S. banks, that we backstop, and because their affiliates may be prudentially regulated when the risk really resides back in the United States, doesn't provide a whole lot, and their personnel are doing this out of the U.S. I'd also add, let me the statement was made that we haven't seen it. I want to go to one of the comments that we received. This was on the arrange, negotiate, execute issue. Stating that I'm reading again from the rule preamble. Stating that A&E, arrange, negotiate, execute transactions could account for a material portion of total swap dealing activity in the U.S. Citadel claimed that market transparency and euro interest rate swaps for U.S. investors has been greatly reduced based on data showing that following issuance of the A&E no action relief, interdealer trading activity in euro interest rate swaps began to be booked almost exclusively to non-U.S. entities. A fact pattern that Citadel believes is, quote, and I'm quoting from this document, a fact pattern that Citadel believes is, quote, consistent with, although not direct proof of, swap dealers strategically choosing the location of the desk executing a particular trade in order to avoid trading in a more transparent and competitive setting, unquote. Citadel further noted that applying regulatory and public reporting requirements to A&E transactions would be consistent with the SEC's approach. So Citadel said that comment, and there's that quote. Now, if you actually, I went back to the Citadel comment, letter on this thing. And I want to, I think it's noted, and I would ask for, I'll note it and then make my request. That quote, it says a fact pattern that Citadel believes is, quote, consistent with, although not direct proof of swap dealers strategically choosing the location of the desk executing a particular trade in order to avoid trading in a more transparent and competitive setting. That's the quote. But that quote is from Citadel's letter, but Citadel's letter with that phrase in turn quotes a study by a Bank of England staff working paper. So we're talking about a Bank of England staff working paper making the assertion there. So let me read the Bank of England staff working paper, and I again beg the indulgence of my fellow commissioners, but this is a really critical point, and the representation was made that we haven't seen it happening, but I'm not sure that is as black and white as it may be. So, okay, let me read from the Bank of England staff working paper, and this was updated in May 2018. So this has been peer reviewed. It's been subject to, I guess it's been peer reviewed. It's subject to whatever economists do. They put these working papers out there. They get comments by other economists, and this isn't like a advocacy organization with an axe to grind. This is a Bank of England staff working paper that we're talking about here. Let me read it. Additionally, we find that for the euro-denominated swap market, the bulk of interdealer trading previously executed between U.S. and non-U.S. trading desks is now largely executed by the non-U.S., mostly European trading desks of the same institutions, i.e. banks have shifted their interdealer trading of their euro swap positions from their U.S. desks to their European desks. U.S. banks have shifted their trading from their U.S. desks to their European desks. We interpret this as an indication that swap dealers wish to avoid being captured by the CEF trading mandate and the associated impartial access requirements. Migrating the euro interdealer volume off CEFs enables dealers to choose who to trade with, and more importantly, who not to trade with. This might allow them to erect barriers to potential entrance to the dealing community. Thus, this fragmentation of the global market is interpreted as dealers trying to retain market power where possible. Importantly, we find no evidence that customers in euro swap markets try to avoid CEF trading and the improved liquidity it delivers. Okay? While our analysis suggests that so far there's been no incremental negative impact on euro contract liquidity as a result of this market fragmentation, it may have negated the liquidity gains experienced in the USD segment of the market. Therefore, given the global nature of the OTC derivative markets, our findings suggest that extending the scope of the trading mandate to cover other sufficiently liquid swap markets would be desirable. So the Bank of England staff study says that the U.S. banks moved their trading from New York to Europe to avoid the CEF trading mandate. That's exactly what they did. That's exactly what we're talking about. Look at the Bank of England paper. That's what they say they did. Staff paper. They say they did it. I'm not saying it. This is the Bank of England staff paper. We talk about relying on economists, and we need to rely on economists, and let's pay attention to the economists. But here's what they're saying. I guess, this is what is passed as prologue. This is an invitation for this all to continue. We just passed a rule on name give up, and they've already been moving their stuff overseas to preserve their interdealer market. According to this, are they going to do it again? If they don't like the rule that we just passed on name give up, are they going to move that activity over into their European affiliates? And what do we have to stop that? And what's the result? It's a loss of liquidity and transparency in U.S. markets. It's a loss of liquidity and transparency in U.S. markets, and that is related to systemic risk in the United States. It's not just some extra trading mandate that's not captured at all by prudential regulation. Prudential regulation doesn't capture trade execution. That's something that is in no way comparable. I'm going to ask the question in our next presentation of whether these jurisdictions these facilities and jurisdictions were going to add onto these for comparability. Just this very question is: do they have anything comparable in terms of name give up. I don't know the answer to that, but regardless of whether it's name give up, they can do that to avoid name give up wherever. I mean, the roadmap to the export of U.S. swap activities to Europe, directly affecting liquidity in our markets, directly affecting transparency in our markets, yet retaining all the risk in New York, to me, this is what this opens up to. Whether it will happen, whether there's tax considerations for this or that, I don't know. Maybe, maybe not. There's all sorts of other factors on where to do these activities. But it just, I think, for me, from the CFTC's perspective, it's impermissible to either permit it or to be agnostic as to whether that happens or not. I mean, we're the U.S. market regulator. We should not be facilitating migration of our markets overseas. And that's what this rule opens up. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I'm sorry.
Go ahead, Josh, if you want to respond to that last point, and then we'll move to round two.
Yes, no, thank you. And I'm sorry, sir. I don't mean to extend the discussion needlessly. I wanted to apologize first to the Commission for my phone having dropped, but I know Frank provided a great answer in my absence. I just wanted to clarify, sir, Mr. Commissioner, before moving on to the point, we're familiar with the Citadel comment. It does indeed get to issues around CEF trading. And I just wanted to observe for the sake of the record that this rule proposal does not address CEF trading, or this final rule, excuse me, my goodness, does not address CEF trading. And indeed, there's language in the preamble indicating that CEF trading is a cross-border rule to be addressed. And so to the extent there's a concern, one you've articulated, this rulemaking does not get into CEF trading and migration of CEF trading. So just wanted to clarify that, sir. Thank you.
Well, that may be true. That may be true. But at the same time, as you're doing this, I don't know where the status is today, but we're just going through a process where you're. Well, let me ask you: Are you concurrent with this action? Are you withdrawing the staff advisory on arrange, negotiate, execute? Is that being withdrawn, and you're providing no relief for unaddressed transaction level requirements? Is that going to happen?
Yeah, I'd like to defer to my chief counsel to respond to that. He's been working very closely on the letter.
Yeah, with the issuance of the final rule today after the vote, we will, the divisions will issue a letter in which DSIO withdraws the staff advisory, and the three divisions provide no action relief for A&E transactions from commission rules that are not addressed in this rulemaking until the commission does final rulemaking. So those are swap clearing and processing, trade execution, and real-time reporting, the other transaction level requirements not being addressed today.
Look at it. So, okay, I appreciate that. Thank you.
Thank you. So we'll move. This is Chairman Tarbert. We'll move now to round two of the questions. But before I begin, though, I want to respond to my esteemed colleague, Commissioner Berkovitz. Just to be clear, my statement earlier didn't say that the guidance had violated the APA. What I said was that it was outside the standard rulemaking process under the APA, which is correct, and that because it was guidance, it's technically unenforceable. So the point about clarity and certainty, and I make this point when I've discussed the difference between rule-based regulation and principles-based regulation, that there needs to be clarity up front as to who's in and who's out, so you can determine whether you go with a principles-based or rules-based approach to whom it applies. So even in the risk principles proposal, which I thank you very much for your work with me on that proposal, it's very clear to who it applies, DCMs. And I think here there were concerns by market participants, and it's in the letters that there wasn't necessarily clarity in the guidance into who's in and who's out. And so I think, as Director Sterling mentioned, the SRS definition, for example, is precise in that regard. And then certainty, of course, if you have guidance, and by definition it's not technically binding, it doesn't have the certainty as a final rule. I want to go back first and just ask some clarification points to DSIO. And then secondly, I want to actually pose a few, what I say are tough hypotheticals, just so we really understand what would happen should these certain risks arise. But first, there was a lot of talk about the guarantee definition, and I guess I just want to get a sense from DSIO. My understanding was the guarantee definition tracks what the SEC promulgated and is also consistent with our clearing rules. Is that correct?
So this is Roger. Yeah, it tracks the SEC and it's consistent with the cross-border margin rule.
Okay, so it's not something that we've we've borrowed this in many ways. It conforms to things that this commission itself has already done, and in fact what our sister agency, the SEC, has done.
Yes, that's correct.
Okay, and then the SRS. There was a question posed. What is the point of the SRS? If in fact we don't think that any actually exist today. Very good question. And I want the American people to hear what I think is a very good answer. And that's that the SRS concept is really designed to prevent a foreign overseas version of Enron or AIG, where we would have a situation where a company that wasn't supervised now, and at the time of the financial crisis, AIG was not subject to consolidated supervision under the Fed, as they subsequently were. And of course, Enron was not subject to any consolidated supervision whatsoever. If they were to look at this and say, well, we don't want to be captured under the U.S. swap dealer rules, we want to move our operations overseas, and not just overseas to a G20 jurisdiction where we would be effectively regulated the same way as we were in the United States, but go to a jurisdiction where there are no regulations. And so the SRS concept is basically designed to address that. So I've got a few hypotheticals that I want to throw at DSIO just to make sure that we've thought them through and at least, I'm comfortable with where we've landed. First of all, let's take the example of the U.S. bank that moves, as others have said. Let's just say it decides, you know what, our swap stuff in New York, we want to move it to London. In that situation, am I correct to say that if it moves to our colleagues in the United Kingdom, they would be subject to, very similar rules and regulations that we have here in the United States, consistent with the G20?
It's Director Sterling, Mr. Chairman. The answer is yes.
Okay. So while it may be a business issue for the United States, a commercial issue, if they decided to move to the United Kingdom, they would be subject to similar regulation.
Yes, sir.
Okay. And let's suppose now that the U.S. bank decides that it's not going to move to its swap desk to the G20. And let's say, I think the current term now is a fragile state. Let's suppose it decides it wants to set up a material and significant swaps trading facility based in a fragile state, and it pays the local warlord some money to go ahead and set up the telecommunications and all of the systems that it needs to conduct this major swaps activity there. Now, it would be out. Now, let me ask you this. First of all, if U.S. persons are the counterparties to any of that swaps activity, would they not be caught by our rules? Assuming they meet the de minimis level.
Yes, sir. If the customer is a U.S. person, then the Dodd-Frank swaps rules would apply to someone that's dealing with them.
Okay, so our whole conversation, and I think it's an important point, involves swap transactions between two non-U.S. persons, effectively, what we're talking about, right?
Yes.
Okay, so let's suppose they go ahead overseas and they set it up in this jurisdiction that doesn't have any of the G20 rules, and they conduct all of their activities with other foreign counterparties, but ultimately, they're subject to the U.S. bank holding company. Now, obviously the Federal Reserve is the consolidated supervisor, correct?
Yes, sir.
And do you think it is likely that the Federal Reserve would allow one of our major banks or systemically important institutions, or even, quite frankly, a regional bank, to set up a major swaps operation in a fragile state? that without any margin or other requirements?
Sir, my understanding of banking regulators is that they would have a problem dealing with a warlord. Yes, sir.
All right. So okay. Well, I feel comfortable with that. All right. Let me take another scenario, which deals with our substituted compliance. Let's say we have a bank based in the United Kingdom that is a registered swap dealer. That they're not a U.S.-based bank. They're headquartered in the U.K., and we have granted them substituted compliance, and they deal with U.S. persons. After Brexit, Brexit has occurred. Let's suppose in the years ahead, the UK, for various reasons, wants to establish itself more as an offshore financial center and no longer comply with the G20 requirements. In that set of circumstances, how would the U.S. rules apply? And particularly, would there be a way of withdrawing our substituted compliance if they no longer have similar rules to protect U.S. persons?
Right. Thank you, Mr. Chairman. So in that scenario, if we have the UK outside the EU, they could no longer have the benefit of the substituted compliance regime absent any other change. So the team can correct me or be more precise, but if they were dealing with a U.S. person, then I think the deal requirements would apply. I invite input from the team on that.
Yes, all of the dealer requirements would comply whenever they dealt with a U.S. person. Subcomp is not available for transactions between non-U.S. persons and U.S. persons.
Okay. And then final scenario, this deals with the SRS. I think we've defined the SRS as being a subsidiary that's 50 billion or more. That's sort of consistent, as was discussed earlier, with kind of historical views of the FSOC and the bank holding, the Federal Reserve and other banking regulators as to what's sort of systemically significant. But let's suppose someone gets really smart, a future version of Enron. So it's not subject to consolidated supervision by the Fed or any other prudential regulator around the world. And rather than putting its $50 billion subsidiary in a fragile state, it decides, well, let's split it up into 3 subsidiaries in 3 fragile states, and therefore none of them itself could be an SRS. I guess I'm wondering there, in that scenario, the Commission's anti-evasion authority, would that be available for us to address that if, in fact, the intent was to effectively set up an SRS, but in a decentralized way to avoid the cross-border rule that we're finalizing today?
Yes, sir. I think that if Enron 2.0, we're going to put those SPVs in different jurisdictions for the purpose of evading our rules, we would have the tools to pursue them for that.
Okay. Well, those were my questions, and like I said, I wanted to just make sure we thought through even what I posed. I think are fairly extreme scenarios that, for all the reasons you said earlier, are highly unlikely. Even highly unlikely that we'd even see major swaps activity move from New York to London, another G20 jurisdiction. But just to sort of pose these tougher hypotheticals to make sure there aren't any big gaping holes where we do think there are major concerns. But given what 2I said about significant risk and its potential impact on the commerce of the United States.
Yes, sir.
Thank you. Well, that's all the questions that I have. Again, I want to thank the staff for your tremendous work on this, as well as those of all your predecessors who have worked on the thorny issue of essentially how do we regulate and to what extent swap dealing activity that occurs sort of outside the United States. With that, I will pass it on to Commissioner Quintens. Commissioner Quintens? Does everyone hear me?
I hear you, sir.
Okay. Commissioner Quintens, are you there? Okay. If Commissioner Quintens has gotten dropped temporarily, then what I would do is we'll move to Commissioner Benham and then go back to Commissioner Quintens when he's back on the line. Commissioner Benham?
Mr. Chairman, do you want to give him a minute, or do you want to just pass it over now? It's up to you.
Why don't we go ahead and just pass it over now, and then we'll go back to Commissioner Quintens when you're finished.
Okay. Thanks, then, Mr. Chairman. Like I said in my first round, I'm going to read at least part of my statement, which will be published shortly on the website. Again, thanks to the staff for their work and their engagement getting us to today. By having a final rule addressing the cross-border application of the registration threshold and certain requirements applicable to swap dealers and major swap participants, CFTC overlooks Dodd-Frank Act purposes, congressional mandates thereunder, an opinion of the D.C. Circuit Court, and multiple comments raising significant concerns. The Commission instead relies on broad deference that opens a gaping hole in the federal regulatory structure. I cannot support a decision to jettison a cross-border regime that has not proven unreasonable, inflexible, or ineffective in favor of an approach that fails to address the most critical concerns that directed the CFTC to address in favor of a more workable solution. As the final rule opts to address the conflicts of economic interest between the regulated and those who are advantaged by it by usurping congressional authority to rethink Section 2I of the Commodity Exchange Act via prescriptive rules, I must respectfully dissent. Almost 10 years ago to the day, Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act as a legislative response to the 2008 financial crisis. Driven by a series of systemic failures, the crisis laid bare that the essentially unregulated and unmonitored over-the-counter derivatives or swaps markets were not the bastions of efficiency, stability, and resiliency they were once thought to be. Title VII of the Dodd-Frank Act gave the Commission new and broad authority to regulate the swaps markets to address and mitigate risks arising from swap activities. Although much of the OTC market contributions to the 2008 financial crisis completed their journey within the continental U.S., the risk originated in foreign jurisdictions. Accordingly, Congress provided in CEA Section 2I that the provisions of Title VII, as well as any rules or regulations issued by the CFTC, apply to cross-border activities when certain conditions are met. The D.C. District Court recognized that Section 2I operates independently without the need for implementing regulations, and that the CFTC is well within its discretion to proceed by case-by-case adjudications rather than rulemaking when applying Section 2I's jurisdictional nexus. The D.C. District Court also found that because the Commission was, quote, not required to issue any rules, let alone binding rules, regarding its intended enforcement policies pursuant to Section 2I, the CFTC's decision to issue the guidance as a non-binding policy statement benefits market participants. To the extent the CFTC interpreted the meaning of CEA Section 2I in its 2013 cross-border guidance, an interpretation carried forward in the final rule today and in its proposal, such interpretation is permissibly drawn linguistically from the statute and regardless cannot substantively change the legislative reach of Section 2I or Title VII regime. In this regard, the interpretation reinforces the direct meaning of CEA Section 2I's grant of authority without implementing regulations to enforce the Title VII rules extraterritorially whenever activities, quote, have a direct and significant connection with activities in or effect on commerce in the United States. The Dodd-Frank Act's derivatives reforms contemplate that an individual entity's systemic riskiness is a product of the interrelations among its various activities and risk management practices. As a result, the post-crisis reforms target the activity of derivatives trading as a means to reach those entities that conduct the trading. As the Commission has acknowledged, quote, neither the statutory definition of swap dealer nor the Commission's further definition of that term turns solely on risk to the United States financial system. And to that end, the Commission does not believe that the location of counterparty credit risk associated with the dealing swap, which is easily and often frequently moved across the globe, should be determinative of whether a person's dealing activity falls within the scope of the Dodd-Frank Act, close quote. By adopting an overarching risk-based approach to cross-border regulation today, the Commission jeopardizes the integrity and soundness of the markets it regulates. The final rule acknowledges that systemic risk may derive from the activities of entities that do not individually generate the kind of risk that would subject them to systemic risk-based regulation, but then chooses not to address that very risk. When the CFTC focuses its regulatory oversight only on individually systemically significant entities, it unavoidably leaves risky activities unregulated that, due to the interconnectedness of global markets individually and in the aggregate, can and likely will negatively impact U.S. markets. Moreover, Congress embedded a risk-based approach appropriate to the Commission's mandate within the Dodd-Frank Act's swap dealer definition by instructing the Commission to exempt from designation as a dealer a person that engages in a de minimis quantity of swap dealing in connection with transactions with or on behalf of its customers, and providing that an insured depository institution is not to be considered a swap dealer to the extent it offers to enter into a swap with a customer in connection with originating a loan with that customer. The Commission seems to have lost sight of the fact that the activity of swap dealing itself presents the type of risk addressed by Title VII. The Commission's ability to establish a threshold amount of such activity that warrants direct oversight via registration does not diminish this underlying trait, which is not binary, but a measure of the scale of risk. Risk is simply in the DNA of a swap dealer. Today's section ignores that, quote, it's the essence of regulation that it lays a restraining hand on the self-interest of the regulated, and that the advantages from that regulation commonly fall to others. In various statements throughout the preamble, the Commission subtly and not so subtly promotes its emergent desire to focus its authority on potential significant risks to the U.S. financial system. In one glaring instance, the Commission responds to a very clear comment on the weakness of the SRS definition in terms of addressing evasion and avoidance concerns by eviscerating Congress's very carefully crafted swap dealer definition, stating, quote, with this risk-based approach, i.e. the SRS model, the swap dealer de minimis threshold, which is a strictly activity-based test, becomes the de facto risk test of when an entity would be subject to the Commission's swap requirements as a swap dealer. In the past several years, I have noted the Commission's eagerness to bypass clear congressional intent in order to address longstanding concerns with Dodd-Frank implementation. Indeed, the Commission has at times made a concerted effort to avoid targeted amendments in favor of sweeping changes to the regulation of swap dealers without regard for the long-term consequences of its interpretation of the law and analysis of risk. I have grave concerns that the final rule's motive in commandeering the role of systemic risk regulator is to provide certainty to entities that they will have sufficient paths in the future to avoid registration with the Commission and thus fly under the radar of the FSOC and the entire Title VII regime. As the D.C. District Court noted, the Commission cannot second-guess Congress's decision that Title VII apply extraterritorially. In layering its new approach over the CEA Section 2I analysis, the Commission does just that. By codifying a purely and defined risk-based approach to its extraterritorial jurisdiction, exempting from the CFTC's regulatory oversight all entities but those which individually pose systemic risk to the U.S. financial system, the CFTC abdicates its congressionally mandated responsibility under CEA Section 2I to regulate activities outside of the United States that meet one of the aforementioned jurisdictional nexuses. The final rule today defies Congress's clear intent in enacting CEA Section 2I, improperly elevates comity over adhesion to the CFTC's mandate, and increases the riskiness of global swaps markets. Congress demonstrated its ability to discern between purely systemic risk-based and activities-based regulation when it designated the authority to the CFTC. It directed the Commission to develop a metric to analyze which entities pose enough risk to require swap dealer registration, creating an exception to the registration requirement for entities engaged in only a de minimis quantity of swap dealing. It's telling that the CEA does not, under Section 2I, direct the CFTC to develop a similar threshold measurement to evaluate whether foreign entities singularly pose systemic risk to U.S. commerce. The lack of a comparable exception in CEA Section 2I indicates that Congress intended to do exactly what the plain language of CEA Section 2I suggests, require that the CFTC oversee activities outside of the U.S. that pose risk to U.S. commerce, not individual persons or entities. Furthermore, nothing in the swap dealer definition or CEA Section 2I expresses that we should defer to prudential regulators, whether U.S. or foreign. Prudentially regulated entities may be required to register as swap dealers with the CFTC. If the Congress believed that prudential regulation could sufficiently mitigate risk to the U.S. financial system, it would have chosen to delegate this function to the U.S. prudential regulators. Congress instead chose to enact a registration requirement in Title VII of the Dodd-Frank Act. Whether or not we agree with Congress, the CFTC is not free to rewrite the statute and enact rules that contravene our mandate. Agencies may not act like they have a blank check to proffer legislative rules outside of their delegated authority. Regulators have to take directives from their governing statute and not second-guess Congress. Thus, the CFTC is not free to disregard its mandate in pursuit of other objectives such as comity, deference, adequacy, workability, or an inexplicable desire to act solely like a prudential regulator, no matter how laudable some of those objectives are. The Commission today dodges the responsibility with which it was entrusted in the wake of a crisis, impermissibly rewriting the Dodd-Frank Act to pass the buck to prudential regulators and our international counterparts. The CFTC's implementation of the final rule's purely risk-based approach to regulating global swaps is neither allowable under Title VII nor is it wise. The current chairman is fulfilling his role as CFTC's representative on the FSOC when supporting guidance signifying the FSOC would adopt an activities-based approach to determining risk to financial stability, stated that an entity-based approach inevitably leads to a whack-a-mole scenario in which risky activities are transferred out of highly regulated entities and into less regulated ones. Given the conglomeration of exceptions built into the final rule's definition of guarantee and SRS and its determination regarding A&E transactions, it's hard to see how this transfer of risk to less regulated entities, which still pose risk in the aggregate to U.S. markets, will not come to pass, inevitably leaving gaps in the CFTC's ability to oversee the activities it regulates. With respect to our cooperation with foreign counterparts, I firmly believe that the CFTC should work diligently to coordinate oversight and elevate principles of international comity as we develop our cross-border approach, but not when doing so requires us to abdicate our mandate. To that end, I generally support the final rule's application of substituted compliance, even if I do not fully agree with entity categorizations via the definitions. I also generally support the CFTC's deference to foreign regulators when it makes sound comparability determinations. To the extent the final rule grants somewhat indeterminate discretion to the CFTC to depart from an objective evaluation in making such determinations, as noted by several commenters, I myself will remain vigilant when participating in such commission action and be mindful of potential for slippage. In my dissent up to the proposal, I identified SRS as the most elaborate departure from both the Commission's interpretation of CEA Section 2I and from our mandate under the Dodd-Frank Act, and its elimination of a large cross-section of non-U.S. subsidiaries of U.S. parent entities from having to count their swap dealing activities for the relevant swap dealer and MSP registration threshold calculations. The SRS replaces the conduit affiliate concept from the guidance, which, although broader, serve to appropriately define the universe of entities whose risks related to swap activities may accrue and have a direct and significant connection with activities in or effect on U.S. commerce, and of course harmonize with the SEC's cross-border application of the de minimis threshold relevant to security-based swap dealing activity. Despite a clear split among commissioners and commenters, the Commission has determined to move forward with the SRS, which creates broad exceptions that could exclude large amounts of the swap dealing activities by foreign subsidiaries of U.S. entities from counting towards the swap dealer and MSP registration thresholds calculations, and therefore ultimately exclude them from the Commission's oversight and application of the swap dealer regulations. In support of its determination, the Commission rehashes and repeats the argument that SRS embodies the Commission's purely risk-based approach. And if this is the way, then I am afraid our new approach may not account, perhaps at all, for the risk that Congress and the Dodd-Frank Act directed the Commission to oversee. If Congress had wanted the Commission to focus its cross-border authority solely on systemically significant non-bank entities, I believe it would have been explicit and refrained from using language in CEA Section 2I that was so embedded in common law. Before I conclude, I'd like again to take a moment to thank staff from the Division of Swap Dealer and Intermediary Oversight for their presentations today, their tireless work over many months on this rulemaking, and frequent engagement with my office over the last few weeks leading up to today's open meeting. Like all of the CFTC's work, today's discussion would not have been possible without the expertise and commitment of our dedicated staff. As the Commission wraps up its scheduled work before a brief summer respite, particularly on this 10th anniversary week of the Dodd-Frank Act, our work yesterday and today, although some may like to think it's not the culmination of years of work towards implementing the Dodd-Frank Act, in fact, the Commission acted promptly in issuing the cross-border 2013 guidance only a few years after bill passage and in the throes of dozens of other equally important Title VII rulemakings. This week's exercise is a retrenchment of sound derivatives policy that provided the CFTC the tools necessary to monitor swaps markets and protect the U.S. financial system and American taxpayers, and most importantly, was steadfast to clearly articulated congressional intent. There's always room for improvement, tweaking, and evolving. I have said as much many times since becoming a commissioner. But unfortunately, during this week that we should be lifting up the merits of financial reform, especially given the role post-crisis reforms played in absorbing massive shocks during the worst of the COVID-19 pandemic just a few months ago, I believe we are turning back the clock to a previous era that proved to be inadequate to meet our core responsibilities. Mr. Chairman, that's it for me. I want to thank you again for your leadership here and thank the team for their work today and in the past few weeks. Pass it back to you.
Thank you very much, Commissioner Benham. Commissioner Quinten.
Thank you, Mr. Chairman. Can you hear me?
Yes, loud and clear.
Okay. Apologize to my colleagues for the difficulties I was having. I could hear fine, but I wasn't able to speak or be heard. So appreciate that consideration. I guess I'd like to start by maybe reacting to a few of the points that were made. Mr. Chairman, I thought you did a very nice job of walking through all of the supervisory the supervisory landscape that firms have to navigate with the challenge of trying to work across borders, serve clients internationally, and keep track of different jurisdictions' rules and how they overlap and whether or not they should. I mean, I think there was some discussion before about banks being aware of what their affiliates are doing, regardless of whether or not they're guaranteed. If there is a non-guaranteed affiliate of a U.S. swap dealer as part of a bank holding company that's abroad, that is subject to consolidated supervision by the Fed. If there is a guaranteed entity abroad that is guaranteed by a U.S. swap dealer, that is subject to CFTC oversight and our rules. Where we come into kind of the crux of the issue is where there are affiliates that are large, that are not part of a bank holding company, where we may have a supervisory interest in their activities. And that's where the significant risk subsidiary comes into play. And I think it's interesting, the discussion around whether or not any of the existing swap dealers would be considered a significant risk subsidiaries, and the answer was likely not. Whether or not there are any new SRS that will have to register, and the answer is uncertain, but possibly not. Maybe that's because we've already registered everybody. And I appreciate the discussion today. I genuinely do, because I do feel like it has laid bare, some different regulatory philosophies. One of which is any swap that has any nexus to any U.S. firm has to follow CFTC regulations tooth and nail, regardless of the risk that can be transmitted, regardless of the involvement, the significant involvement of U.S. personnel, regardless of the subcomparability that's been issued to overseas jurisdictions. And then there's the alternative that we have today, which, while creating regulations, acknowledges the complex landscape in which these firms operate, acknowledges the progress of G20 jurisdictions in implementing rules, acknowledges our ability to grant substitute compliance, which we already have for Group A and B in multiple jurisdictions, including Japan and the EU, with some exceptions, acknowledges the oversight of the Federal Reserve, but acknowledges that we have a supervisory interest as well, and acknowledges the irrefutable language of the statute that constrains our ability to look at overseas activity. And it's activities that have a direct and significant effect on commerce in the United States that we have to be concerned about. And, while it's activities that create that effect, in order to have that effect, they have to have some kind of risk. So the debate around, is it activity-based, is it risk-based? We can also talk about the de minimis threshold. I challenge anyone to defend whether or not notional value is an appropriate threshold for that process and to defining what a de minimis amount of swaps is. In anyone's discussion of an activity versus risk-based analysis of that threshold and construct, I haven't heard anyone ever say that notional value is the best metric to use. And if that's the case, then I think a lot of the rest of this in the discussion makes some kind of sense. But going beyond that, I think I'm just going to leave it there. I'd like to read some of my statement, which is, and first of all, to thank the DSIO team that has been so deeply involved in this very complicated rulemaking for so long. And I'm very pleased to support that work today in a final rule that appropriately interprets Congress's statutory directive that the Commission may only regulate those foreign activities that have a direct and significant connection with activities in or effect on commerce of the United States. And as I noted when I supported the proposal in December, Congress deliberately placed a clear and strong limitation on the CFTC's extraterritorial reach, recognizing the need for international comity and deference in the global swaps market. And today's rule achieves the goals for cross-border regulation that I tried to articulate in October of last year, where I stated that each jurisdiction's recognition of and deference to the sovereignty of other jurisdictions is crucial in avoiding market fragmentation that itself poses serious risks to the liquidity and health of the derivatives markets. I'd like to quickly talk about substitute compliance and the A&E construct. As I noted with respect to the proposal, substituted compliance is the linchpin of a global swaps market, and the absence of regulatory deference has been the fracturing sound we've heard as that market fragmented. The final rule provides a framework for substitute compliance with respect to two sets of regulations: Group A entity-level requirements, such as conflicts of interest policies and a risk management program, and Group B transaction-level requirements, such as daily trading records confirmation and portfolio reconciliation. While the Commission has issued substituted compliance determinations for entity-level requirements in 6 jurisdictions and for transaction-level requirements in 2, they all contain exceptions for particular provisions of the Commission's regulations, and one of the transaction-level determinations partially addresses only 2 of the 5 regulations in our Group B requirements. Today's rule provides for a flexible outcomes-based framework for future comparability determinations that will assess the goals of the Commission's regulations against the standards of its foreign counterparts' regimes, instead of directing the Commission to focus on a rigid line-by-line or even regulation-by-regulation comparison. More specifically, and a primary reason for my support of this final rule is that under this new framework, the Commission can compare the goals of its regulations to the outcomes of foreign regulations on an entire group-wide basis, so that the standards of a foreign regime will be considered holistically compared to the goals of all the Commission's either Group A or Group B requirements. Additionally, this final rule allows the Commission to proactively assess and issue comparability determinations without waiting first for a request from a foreign jurisdiction. I recognize that several G20 jurisdictions have made significant progress in the area of issuing transaction-level requirements, as evidenced by a recent report of the Financial Stability Board. I hope that the Commission will soon issue additional substituted compliance determinations in order that foreign firms registered as swap dealers with the Commission, as well as foreign branches of U.S. swap dealers, can gain the efficiencies of complying with local laws for many of their transactions with non-U.S. persons. Ideally, future determinations will provide for comprehensive holistic substituted compliance in a particular jurisdiction for all transaction level requirements in the CFTC's Group B. Let me finally talk about A&E. And there was a lot of discussion around the 2013 guidance and what the court ended up determining on it in that legal challenge. And from what I can tell, the court dismissed the case not because the guidance complied with the APA, because the guidance was outside of the application of the APA. But yet what it also did was it remanded back to the CFTC the rules that were implicated by the guidance for insufficient cost-benefit analysis. And I think it's interesting to note the Commission's standard for cost-benefit analysis, which I view as being very disappointing statutorily, as not requiring the Commission to quantify costs and benefits, but only that they be considered. And yet the Commission didn't even do that. So to say that the district court validated the guidance on APA grounds, I think is a stretch in terms of my own interpretation of that ruling. But today's rule properly eliminates the possibility that a non-U.S. swap dealer be required to follow many of the CFTC's transaction level requirements for a swap opposite a non-U.S. counterparty if U.S.-based personnel of that swap dealer arrange, negotiate, or execute the swap. This action brings to a close almost 7 years of uncertainty, beginning with, in my view, the misguided advisory from November 2013, which was not subject to public comment and which was not issued by a vote of the Commission. I note that the staff's no-action letter issued this week suspends enforcement of A&E with respect to transaction-level requirements not covered by today's rule, specifically in the areas of real-time reporting of swaps to swap data repositories and the clearing and trade execution requirements, pending future Commission rulemakings that address these rules in a cross-border context. I expect the Commission will issue such rules in the near future in order to provide the marketplace with legal certainty in these areas and formally dispense with the A&E construct, just as it has with respect to the requirements addressed today. I believe strongly that A&E has no place with respect to real-time reporting, the clearing requirement, or the trade execution requirement, just like it has no place with respect to the business conduct regulations. With that, Mr. Chairman, I'm very pleased to support the rule, and I very much thank you for your leadership and the DSIO team for this product.
Thank you very much, Commissioner Quintens. Commissioner Stone.
Thank you, Mr. Chairman. I just want to make a couple of clarifications in response to a few comments that were made by others. In describing earlier, when I described the need for updated definitions of guarantee, I did not intend to suggest that I have any interest in departing from principle-based regulation. In fact, you will rarely hear me suggest that we need more prescription in the application of our rules. Rather, I draw a distinction between clarity and prescription. In fact, for my Commission colleagues who join me in closed meetings where we consider enforcement matters, I believe I am quite consistent and vocal about the need to have clearly defined parameters in our rules if we are to effectively hold market participants accountable. On another point, which is the interpretation of 2I, and again, I'll make this quick. I know we've discussed 2I ad nauseum, but because the final rules essentially codify the guidance, and because I support the need to do so rather than start from scratch, I accept the interpretation of Section 2I stated in the guidance and the final rule in the limited context of registration thresholds and regulatory requirements applicable to swap dealers. To codify the guidance while revising the foundation on which it was based would only generate confusion, as opposed to the clarity that I hope this rulemaking will bring. But as we proceed with other aspects of the cross-border work in areas such as clearing, trade execution, and reporting, rigorous analysis of Section 2I for each rule we adopt is necessary to ensure that the law is followed both to the letter and the spirit. I do not want my vote today to be interpreted as an endorsement of the interpretation of 2I in this rule as a blanket interpretation of 2I as we go forward. Just a few words about international comedy, which, contrary to the views of some, is not simply a buzzword the Commission invokes to justify what critics believe is an improper easing of regulations in the cross-border activity. I emphatically reject the notion that appropriate deference to international regulatory authorities weakens oversight or protections of our markets, market participants, or even the financial system. When the Commission issued the guidance in 2013, only a few derivatives reforms had been adopted in a few other jurisdictions. How things have changed since then. Many of our fellow regulators around the world and in major financial centers have implemented reforms governing the conduct of swap dealers commensurate to our own. And extensive strides have been made and continue to be made towards international harmonization, thereby aligning our regulatory principles as envisioned by the G20 in the midst of responding to the financial crisis in 2009. As a result, most swaps involving non-U.S. counterparties today, unlike when the guidance was adopted, are expected to be subject to foreign regulatory requirements similar to the Commission's own. In applying the G20 recommendations, Congress, in Section 752A of the Dodd-Frank Act, specifically directed the Commission, and I quote, in order to promote effective and consistent global regulation of swaps, to consult and coordinate with foreign regulatory authorities on the establishment of consistent international standards with respect to the regulation of swaps and swap entities. Congress recognized that global swaps markets cannot function absent consistent international standards, something that has taken 10 years to develop. Thus, regulation of global swap markets that impose overlapping and duplicative requirements now, 10 years later, on swap dealers and their cross-border activities by multiple regulators is inconsistent with Congress's direction to the Commission, the vision of the Group of 20 leaders in Pittsburgh in 2009, and as the chairman explained earlier, it's simply not workable. So now 10 years since the passage of Dodd-Frank and 7 years since the issuance of the guidance, these swaps are also likely to be subject to regulations in another country. So the U.S. has an interest in these transactions, and another jurisdiction is also going to have an interest in these transactions. So what these provisions in the final rule are doing is identifying certain circumstances in which we have determined that given limited risk to the U.S. financial system, the other country has a paramount responsibility and regulatory interest. And I would also point out that since the issuance of the guidance, the CFTC has issued 11 comparability determinations regarding the regulation of swap dealers in the European Union, Canada, Japan, Australia, Hong Kong, and Switzerland. Again, I don't mean to belabor the point, but international comity is something that makes our global swaps market safer. It should not be viewed as something that is weakening our regulation. International coordination was expected during the crisis, after the crisis, and today. So international coordination also requires that we trust one another, that we work with our colleagues in other jurisdictions to ensure we have achieved our goals. In conclusion, I support codifying our prior cross-border guidance into enforceable rules, and I believe the final rule before us today is clear, sensible, and workable. These rules improve upon the guidance based on our experience in administering the Dodd-Frank swap regulatory regime over the past several years, and they recognize the current state of global regulation and the global interconnectedness of derivatives markets by carrying on this agency's established tradition of mutual recognition and substituted compliance. I want to very much thank the staff of the Division of DSIO, as well as the General Counsel's Office and Chief Economist's Office, and all of those who had a hand in putting this rule, in developing this rule and putting it forward such that we can finally provide the clarity that swap dealers require and that the swap markets require. I am particularly appreciative of the time that the DSIO staff devoted to answering our questions today, always in a thoughtful and comprehensive manner, in reviewing and addressing the various comments and requests from me and my team over the course of the past few months. With that, Mr. Chairman, I'm happy to support the rule, and I will turn the microphone back to you.
Thank you very much, Commissioner Stump. Commissioner Berkovitz.
Thank you, Mr. Chairman. I'm not going to read my statement. I've got just a couple more questions. I want to use my time for that. But I also want to just note a couple things again in response. And I think it's healthy. I think it's healthy that we have a dialogue rather than serial monologues. I welcome that. I think it's constructive. So a couple things I just want to stress. First, it's in the release, and it was mentioned previously that the definition of guidance in this rule is consistent with the definition of guidance in the cross-border margin rule, and that is true. But the cross-border margin rule basically also dealt with a very similar question: when should U.S. law apply and our margin requirements apply to the cross-border swaps of affiliates of U.S. entities overseas? It's virtually the identical question that we're considering today in the margin context rather than in the registration or the trading context. And in that rule, we harmonize with the prudential regulators' approach to a large extent. Yes, there was a narrower definition of guarantee, but there were two prongs. So basically, you got under the cross-border margin rule, if the entity in the U.S. was guaranteed by this narrow definition of guarantee, or it was a foreign consolidated subsidiary, our margin rules would apply. It included the concept of foreign consolidated subsidiary in addition to the guarantee. It had two tests: guarantee or foreign consolidated subsidiary in this regard. We dropped the foreign consolidated subsidiary test in favor of this SRS construct. So you need the full picture to understand. If you're going to say, well, we did this, it's the same as the margin rule, but we didn't adopt the foreign consolidated subsidiary in the margin rule either. So we're not really following the margin rule on this. This is narrower than the guidance, and it's narrower than the margin rule. Secondly, just want to emphasize again that this is not about whether there's substituted compliance or not about whether we're going to regulate every transaction with a connection to the United States. This is when we are going to regulate entities that have significant connections with the United States, and at a certain point, the interest in the U.S. is stronger than the interest overseas. And as I stated previously, one of those interests is when all the activity is in the U.S., when the activity is booked in the U.S., or effectively when the risk is borne in the U.S., even though it may be booked overseas. We can't, under this construct, we should not allow legalistic structures to avoid U.S. regulation when the impact in the U.S. is the same as if it had been conducted from the U.S. And so we've been talking about generally when our regulations apply outside the United States. After all, 2I and the provisions that we're talking about, comity, 2I refers to conduct outside the United States. That's when we go through this weighing and balancing and the considerations of international comity and the restatement of law, of foreign relations law that the interpretation relies on, all deals with conduct in another jurisdiction. So I want to talk about for a moment conduct within the United States. And again, let me read from the preamble to the rule. As discussed in the proposed rule, the Commission is using the terms foreign-based swap and foreign counterparty to identify the types of swaps that are eligible for certain relief, consistent with Section 2I of the CEA, in order that swaps that demonstrate sufficient indicia of being domestic generally remain subject to the Commission's requirements under the final rule, notwithstanding that the swap is entered into by a non-U.S. swap entity or a foreign branch of the U.S. swap entity. Otherwise, an entity or branch might simply be established outside the United States to evade Dodd-Frank Act requirements and CFTC regulations. As the Commission has previously stated, it has a strong supervisory interest in regulating swap activities that occur in the United States. However, consistent with Section 2I of the CEA, foreign swaps of non-U.S. swap entities and foreign branches of U.S. swap entities should be eligible for relief from certain of the Commission's requirements. So let me focus first on that. Foreign branches of U.S. swap entities eligible for relief. And I think this is something that's under the guidance as well. To what extent, and don't feel obligated to give me to recite the tables, every box in the table, but generally, how do we treat foreign branches of U.S. swap entities?
This is Lauren. So they do have substituted compliance when dealing with other foreign branches or guaranteed entities, swap entity SRSs, or other non-U.S. persons.
So if a foreign branch of a U.S. entity, so we have a U.S. bank and it has a branch overseas, and it's doing a swap with a third jurisdiction. So let's say a branch in London is doing a swap with an entity in Hong Kong, we would give that U.S. branch substitute compliance with the law of the U.K. Is that correct?
Yes.
And in that situation, we say, well, although the branch is that interest of the UK and the activity of that branch in the UK, because it's actually doing activity in the UK, outweighs our interest. The home interest jurisdiction of the US in that branch, the international comedy, we defer to the UK.
Correct.
So let's take the reverse. Let's take the reverse situation. There's a UK bank-based bank that has a branch in New York that does the swap with Hong Kong. What happens there?
There's also substituted compliance available there.
So in the case of the U.S. bank in London, we state that the British interest, or the English interest, the British interest is greater, and we're going to defer to them. Why don't, if our bank is in their territory, so if their bank is in our territory, why don't they defer to us? Why is in both situations, whether the swap is in London or New York, we deferring to somebody else? Why isn't our interest in the domestic activity in New York sufficient to outweigh the British interest when the British interest outweighs our interest when it's on the other side of the Atlantic? Why do we end up deferring in both situations and they don't defer at all? Why don't they defer to us?
Well, I think, commenters generally ask us to expand the scope of substituted compliance pretty broadly, in some cases to even include swaps with U.S. persons. And we continue to believe that Congress intended for Dodd-Frank to apply fully to U.S. persons other than their foreign branches with no substituted compliance available. So therefore, we believe that the expansion of subcomp for the Group B requirements for U.S. persons was not appropriate. But in considering that, we acknowledge that a swap booked in a U.S. branch of a non-U.S. swap entity with a foreign counterparty that is neither a foreign branch nor guaranteed entity does have a comparatively smaller nexus to U.S. commerce than a swap booked in a U.S. branch with a U.S. person, a guaranteed entity, or another branch. And we'd also note that substituted compliance is only available where a foreign jurisdiction has comparable regulatory standards and a comparability determination is in place for that jurisdiction.
Yeah, I understand that, and actually, I think it's I'm supportive of granting subcomp to. I'm supportive of granting substituted compliance to the U.S. The Bank of the U.S. branch in London if they're doing a swap with Hong Kong, but I would expect then that if the swap were out of New York done by a UK branch under that same principle, that the location in which that branch is, that's the governing law. What we're saying for the U.S. branch in Britain, that because it's in Britain, British have a greater interest But if the shoe is on the other foot and it's in New York, again, the British have the greater interest. I don't understand why their interest always outweighs ours, no matter where the swap is, no matter where the swap is booked. In every instance, we defer to them. We never defer.
It depends on where that counterparty is. If a non-U.S. person is operating through a branch in the United States and they're doing business with a U.S. person, or the foreign branch of a U.S. person, or the U.S. branch of a non-U.S. person, or a guaranteed entity, or an entity that's guaranteed by a U.S. person, then then the CFTC rules apply. No substitute compliance available. It's only when they're booking it in the U.S. branch but doing the deal with the SRS or an other non-U.S. person where, as Lauren stated, the nexus becomes more attenuated, and we thought it seemed that subcom should be available for those.
So, that's I appreciate that clarification, and I support the application of the provisions and the unavailability of subcomp in the situations that you identified. But then again, with the SRS and a non-U.S. person, there's not a two-way street on subcomp. We're always giving it up, which I don't understand why it makes difference which jurisdiction it is. If the principle is that the home jurisdiction of the jurisdiction in which the transaction is occurring has a greater interest in which the branch is, if it's with if it's with like Hong Kong, if it's a transaction that's in a third country, party in a third country who controls, it would seem that there would be a common principle, but we're deferring in both situations, whether it's a U.S. Branch of a U.S. bank in London or a branch of a London bank in New York. If they're for that Hong Kong swap, we defer in both situations. That raises the issue because the language that I read stated, consistent with Section 2I of the CEA, foreign swaps of non-U.S. swap entities and foreign branches of U.S. swap entities should be eligible for relief. So we've covered the foreign branches of U.S. swap entities. Foreign swaps of non-U.S. swap entities should be eligible for relief. And the court and the commission goes on to say in the preamble, certain exceptions from the Group B and C requirements and portions of the substitute compliance regime, just below, et cetera, are designed to apply only to certain foreign swaps, of non-U.S. swap entities and foreign branches of U.S. swap entities that the commission believes should be treated as occurring outside the United States. And then it says specifically these provisions are applicable only to a swap by a non-U.S. entity except for a swap booked in the U.S. branch. So the principle here, if I can clarify this, it gets confusing, all the foreign swaps, branches, and entities, but basically the principle is that if a transaction is occurring in the United States, it should be subject to U.S. law. And I don't think 2I even applies if it's in the United States. 2I applies only to conduct outside the United States. The rule has a definition of foreign swap, as I take it. How does the rule define a foreign swap?
So this is Jake Jagan. So the definition of foreign-based swap, which is a swap by a non-U.S. swap entity or foreign branch, where for the non-U.S. swap entity, it is not conducted or booked in a U.S. branch rather, and for the foreign branch, it is a swap conducted through the foreign branch. So those terms are used to try and not include swaps that are booked in the U.S. and only include swaps that we think are endemic to the foreign market and are therefore meet the definition of a swap conducted through a foreign branch. And if you look at the exceptions, all but the U.S. branch Group C exception is only available for foreign-based swaps, and that's kind of where the language you're reading relates to in the rule.
So clarify. So a swap booked in a U.S. branch. That's what a swap booked in a U.S. branch that is with a swap booked in the U.S. branch is not a foreign-based swap, right?
No, that's correct, yes.
Okay, so how does a swap booked in the U.S. branch that's not a foreign swap gets substituted compliance. If that's like a bank, a foreign bank in the United States, a branch of a foreign bank in the United States, that the swap is booked in the United States, it's arranged, negotiated, and executed in the United States, and I think according to the definition of foreign branch, it's actually regulated in the United States, it's regulated in the U.S., it's booked in the U.S., the people doing it are in the U.S., it's not satisfying the definition of foreign-based swap. How does that get substituted compliance when substitute compliance is only available for foreign-based swaps?
It wouldn't get substitute compliance. It would only be available for foreign-based swaps from the Group B requirements, the transaction requirements.
So a swap of a non-U.S. person booked in the U.S. branch, that where its counterparty is an SRS or an other non-U.S. person is eligible for substituted compliance. Again, because the counterparty, we're talking about a non-U.S. person, yes, they're booking it in their U.S. branch, but their counterparty is also a non-U.S. person that is not guaranteed by a U.S. person, and the nexus is somewhat more attenuated, so subcomp is available. Not deference, but subcomp is available.
Yeah, I understand that, but it's not a foreign-based swap. It doesn't meet the definition of foreign-based swap because it's booked in the U.S. So I'm just having a hard time how we're giving subcomp to something that's not a foreign-based swap. It's booked in the U.S. This entity is conducting the swap activity from the U.S. Just, the counterparty in Hong Kong calls up this thing in New York. Is that, presumably, but that's not a foreign-based swap. You've excluded it. So it seems contradictory to give subcomp to activities that are essentially in the United States.
And one thing to keep in mind also is it's not a foreign-based swap, but it is ultimately a swap between two non-U.S. persons.
Well, here again, yes, that's correct. The interesting thing about this is that the entity is ultimately owned outside the U.S., but in this instance, a U.S. branch, according to the definition of the final rule, is the books are in the accounting. The books are in the United States. It's subject to U.S. banking regulation. It's done in the United States. Its ultimate holder is outside, but like the accounts and books and everything is here in the U.S. So I think this is an extreme stretch. I don't think we can. If you're going to define it as activity, if you can't define it as activity outside the United States or foreign-based swap, I have a problem with applying 2I and giving foreign deference really to essentially what's going on in New York. I mean, it's applying UK law to this entity's activities in New York when we recognize UK law applies to our entities in London, but then we apply British law to activity in New York. This is a bridge too far, in my view. So, okay, that concludes that includes my my questions, and I think I've expressed the concerns I have with this final rule. I would just, thank you.
Thank you very much, Commissioner Berkovitz. I'm sorry, did Director Sterling or anyone have anything further to say?
No, sir, although one thing I was remiss in saying, I wanted to thank Matt Dagler and Chelsea Pizzola in your office for all their help to us during these many months. So I will interject that.
Okay. So with that, I will ask and very much appreciate all of the robust discussion on this, very complicated final rule. Is there any commissioner who is not prepared to vote? Okay, then I will ask Mr. Kirkpatrick, our secretary, to please call the roll for the final rule on the cross-border application
of the registration thresholds and certain requirements applicable to swap dealers and major swap participants.
Thank you, Mr. Chairman. This is the Secretary speaking. The motion now before the Commission is on the adoption of the final rule on the cross-border application of the registration thresholds and certain requirements applicable to swap dealers and major swap participants. Commissioner Berkovitz.
Commissioner Berkovitz votes no.
Commissioner Berkovitz votes no. Commissioner Stump.
Commissioner Stump votes aye.
Commissioner Stump votes aye. Commissioner Benham.
Commissioner Benham votes no.
Commissioner Benham votes no. Commissioner Quintens.
Commissioner Quintens votes aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Chairman Tarbert votes aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 2.
Thank you very much, Mr. Secretary. The ayes have it, and the motion to adopt the final rule is hereby approved. Now we will move to our second agenda item, which I think will be a little bit more straightforward than our first agenda item, which did result in a lot of robust discussion, and I think it was very healthy, and very much appreciate my colleagues' time and attention to discussing that. The second item is deals with an amendment order exempting certain multilateral and organized trading facilities authorized within the European Union from registering with the CFTC as swap execution facilities. And so at this time, I'd like to invite a staff presentation on this amendment order. And from the Division of Market Oversight, we have Dorothy DeWitt, our director, Roger Smith, special counsel. Dorothy and Roger, I will hand the floor to you.
Thank you, Mr. Chairman. You able to hear me fine?
Yes, you're a little in and out, but I can hear you.
Okay. This is Dorothy DeWitt, the director of the Division of Market Oversight, and if I continue to have issues with connectivity, please interrupt, and I'm more than happy to just turn it over to Roger Smith, my colleague. My remarks will be very short. I wanted to thank you, Chairman and Commissioners, and on behalf of my colleague Roger Smith and myself, I would like to thank our current and past Commission colleagues who were instrumental in our work on this effort. Tom Benison, Suyash Palawal, Nora Flood, Vince McGonigal, Dana Brown, David Van Wagner, Amir Zaidi, Carlene Kim, Harissa Nouri, Eileen Donovan, Sam Wasserman, Ed Ricobin, and Brent Tomer. We would especially like to thank Mauricio Malara for his help throughout this process. Further, we would like to thank our colleagues at DG FISMA for their efforts on this matter, and we look forward to continuing to work closely and collaboratively with them on this and other matters of mutual interest. Finally, we also want to thank the commissioners themselves and their staff for their thoughtful consideration and feedback leading up to today's meeting. I will now turn it over to my colleague Roger Smith for the BMO staff presentation. Roger?
Thank you, Dorothy, and thank you, Chairman, for the opportunity to present staff's recommendation. Today, staff is recommending that the Commission exempt 16 additional multilateral trading facilities, or MTEFs for short, and organized trading facilities, or OTEFs for short, that are authorized within the European Union, as well as issue an amendment that would clarify the application of the EU 5HC exemptive order to UK-based MTEFs and OTEFs during the Brexit transition period. CEA Section 5HC authorizes the Commission to exempt conditionally or unconditionally a swap execution facility, or SEF, from registration under CEA Section 5H if the Commission finds that the facility is subject to comparable comprehensive supervision and regulation on a consolidated basis by the appropriate governmental authorities in the home country of the facility. Facilities that are granted an exemption from self-registration pursuant to CEA Section 5HG are also eligible facilities upon which counterparties may satisfy the trade execution requirement under CEA Section 2HE. In December 2017, concurrently with the European Commission's determination that CFTC, CES, and DCMs were equivalent for purposes of satisfying their trading obligation under MIFIR Article 28, the Commission determined that the EU's regulatory frameworks for MTES and OTES respectively satisfy the standards set forth under CEA Section 5HG in order to be exempted from registration as a CEF. As a result, the Commission issued an order exempting 16 MTES and OTES from CEF registration requirements. In December 2018, this order was amended to add 4 additional EU-authorized MTES to the original list of exempt EU trading facilities. Since 2018, DMO staff and our colleagues in OIA have engaged with our colleagues at the European Commission's DG FSMA in an open dialogue about potential exemption of additional EU trading facilities, including the addition of trading facilities located in France, Germany, the Netherlands, Spain, and the UK. Consistent with the terms of the 5HG order that the Commission issued in 2017, DG FSMA staff has confirmed that each of these MTES and OTES is authorized and in good standing in an EU member state that has completed its transposition of the MiFID II requirements. Further, DG FSMA staff has confirmed that the EU member states where these MTES and OTES are located provide reciprocal access to CFTC exchanges. Therefore, today staff is recommending that 16 additional MTES and OTES located in these jurisdictions be exempted from CEF registration under CEA Section 5HG. In addition, staff is also recommending that the EU 5HG order be amended to clarify the application of the order to UK trading facilities during the Brexit transition period. Following notification on March 29, 2017 by the UK to the European Council in accordance with Article 50 of the Treaty on the European Union of the UK's intention to withdraw from the EU and the European Atomic Energy Community, also known as Euratom, the UK entered into a withdrawal agreement effective February 1st, 2020 with the EU and Euratom. Pursuant to this withdrawal agreement, as established in UK law pursuant to domestic legislation, the EU-wide requirements that apply with respect to MTES and OTES will, for the duration of the transition period, continue to apply to UK-based MTES and OTES. Further, the European Commission has confirmed that during the transition period, references to the EU member state or an EU member state in certain representations made to the CFTC shall be construed to refer to and include the UK. Accordingly, staff recommends that the EU 5HG order be amended to make clear that during the transition period, the EU 5HG exemptive order continues to apply to UK-based MTES and OTES. Finally, staff recommends 2 clerical changes. The first updates the home country of an MTES listed in Appendix A to the order, and the second removes 2 EU trading facilities that have been registered as CEFs from the list of EU trading facilities that are exempt from CEF registration requirements. This concludes our opening remarks. Thank you for your time and consideration of this important issue.
Well, this is Chairman Tarbert. I want to thank Dorothy and especially you, Roger, for your excellent presentations. To begin the Commission's discussion and consideration of these matters, I'll first entertain a motion to approve the amendment order exempting certain trading facilities authorized within the European Union from registering with the CFTC as swap execution facilities.
So moved. Second.
Thank you. I'd now like to open the floor for commissioners to give statements or ask any questions in order of seniority. I'll begin, and quite frankly, this is very easy for me because I agree with the recommendations of staff for all of the reasons that you outlined, Roger. So the only thing I want to potentially add as sort of chairman is just to speak to our audience here in the United States, but also abroad, to convey my view that today's amendment to the 5HG order, I think, is another important step in our efforts to build a transatlantic framework that is cooperative and efficient and reflects mutual respect and deference. Coupled with our high regulatory and supervisory standards, we can work with our European partners. In other words, it must be a two-way street. Today's action is based on continued signs that the European Commission and the European Securities Markets Authority are working in good faith to build an appropriate degree of deference into their own implementation of the European Market Infrastructure Regulation known as EMIR 2.2. In that regard, I'd like to note that just last week, on July 14th, the European Commission adopted 3 delegated acts under EMIR 2.2. These acts address European supervision of third country central counterparties and the extent to which they should be subject to heightened supervision by European regulators. The standards set forth in the delegated acts, in my view, are predictable, proportionate, and designed to provide an appropriate degree of deference to home country supervision. So I look forward, on behalf of the agency, to continued engagement with our European counterparts to advance our shared interests in curbing market fragmentation and strengthening reciprocity. So in that larger sense, as well as the specific reasons that you articulated, Roger, I'm pleased to support the amendment today. And with that, I will hand it over to you, Commissioner Quintens.
Thank you, Mr. Chairman. This is Commissioner Quintens. I would first of all just like to thank the staff for the hard work on this, Dorothy and the whole team. And I would also like to acknowledge that Dorothy in her comments referenced a number of staff that were under the prior chairman and are no longer here. And I think that really speaks to how many people are involved with these kind of determinations and how long they take, and that the efforts under one chairman can continue to benefit the commission into new regimes and new times. So let me thank everyone that she listed without going through the list myself. I don't have any questions, but I would like to read a statement that I support today's action by the Commission to amend the order that exempts 2 types of trading facilities authorized within the EU from registration with the CFTC as CEFs. As amended, the order will authorize an additional 16 trading facilities to access U.S. eligible contract participants without complying with CFTC regulations or being subject to the Commission's oversight. These trading facilities, located in France, Germany, the Netherlands, Spain, and the UK, include the first EU-authorized trading facilities located outside of the UK to benefit from the order. Today's amended order exemplifies the Commission showing deference to a foreign regulatory counterpart. Congress established a framework for non-U.S. trading facilities to be exempt from CEF registration if the Commission establishes that they are subject to comparable, comprehensive supervision and regulation. This provision directs the Commission to show deference to its foreign counterparts when appropriate. When exercised properly, deference eliminates duplicative regulatory burdens for market participants, conserves the Commission's resources, while still protecting market integrity. Other provisions of the Commodity Exchange Act also provide for a policy of international deference, including the provision exempting from registration comparably supervised foreign DCOs, and on a broader level, the provision limiting the Commission's authority over foreign swaps activity that we just described in our prior dialogue. A successful policy of deference depends on the CFTC having foreign regulatory counterparts that honor their cross-border commitments. In 2018, I stated that I would neither support the CFTC granting additional equivalence determinations within the EU, nor would I support any relief requested by EU authorities until the EU recommitted to honoring its 2016 agreement with the CFTC on CCP oversight. That agreement, in my view, had been in jeopardy since the EU's issuance of EMIR 2.2 in 2017, which raised the possibility of EU authorities directly supervising U.S. clearinghouses and requiring them to comply fully with EMIR. Since then, I have objected to staff no action relief to a CCP located in the EU and to the Commission's registration of 3 foreign boards of trade located in the EU. Last week, however, the European Commission adopted 3 delegated acts regarding EU supervision of third country CCPs, including those located in the U.S., and these acts set clearly defined numerical thresholds at which point such CCPs would be subject to European regulation and supervision as Tier 2 CCPs. I believe these thresholds reasonably withhold European regulation until the CCP genuinely poses systemic risk to the European market, and therefore are in the spirit of the 2016 agreement on CCPs between the CFTC and the European Commission. I recognize that while these delegated acts remain subject to review by the European Parliament, their adoption is meaningful and warrants my approval today for today's action for EU trading facilities, and allows me to revert back to what I think would have been my benchmark position on these issues to begin with. Furthermore, I note that European authorities currently permit U.S. CEFs registered with the CFTC to access European market participants without subjecting those CEFs to EU supervision and regulation. In closing, let me thank the staffs of the CFTC and the European Commission for their cooperation and support of today's amended order. I hope to be in a position to support additional acts of international deference with the EU in the future. Thank you, Mr. Chairman.
Thank you, Commissioner Quintens. Commissioner Benham.
Thanks, Mr. Chairman. Just a single question for the team, and of course, as always, thank you to Dorothy and Roger for your work and working with my office, and all the individuals, Dorothy, that you pointed out have worked on these issues over the years, recognizing their hard work and dedication in putting this together. Roger, I assume this question is for you. It's fairly basic, but I think a little clarification for me and I think for the public would be helpful. In Appendix A, there's a transition period that's established specifically for the UK's with withdrawal agreement from the EU. I think as of now, the transition period ends at the end of this calendar year, but can you just sort of explain what will happen to the UK entities, specifically with regard to Appendix A, when that transition period ends at the end of the year? Thanks.
Thank you, Commissioner Benham. I appreciate your question. So, as you correctly point out, the UK at the end of this year, while it is technically currently not an EU member state during the pendency of the transition period, it is treated as if it is an EU member state, but at the end of this calendar year, that transition period will end. For our purposes, staff in April of 2019 issued no action relief, which provides certainty to UK-based MTES and OTES that when that transition period ends, they'll continue to still be covered by the exemptive order while the staff of the CFTC works through a final determination for UK-based MTES and OTES.
Thanks, Roger. Appreciate that answer, and I will say, Mr. Chairman, I'm happy to support the order today, and in the vein of what we've been discussing since 10 a.m., this is certainly within the context of our global markets and our cross-border regulation. have in the past. I've said many times, and I've acted in such a manner to support substituted compliance, working with our counterparts overseas, ensuring reduction of market fragmentation to the extent it's possible. Of course, while ensuring what we need to do as an agency, as a commission, to preserve American markets and to support and protect American taxpayers. But as the market continues to evolve, as we deal with new challenges every day, whether it's a Brexit issue, a pandemic, or any number of other smaller, more geographically located issues, we have to adapt. We have to be flexible, and I know we are. But it's decisions like today that I think really shine light on the importance of patience working together and how our markets truly have changed over the past 10 years. And although not as quickly as many would hope, I think we continue to sort of chip away at working towards better, stronger, more resilient markets. And I think that's evidenced again in hopefully what will be unanimous support for this decision. So thank you, Mr. Chairman. Thanks to the entire team for putting it together. A lot I know rested on negotiations through OIA in addition to PMO. So thanks to everyone. That's all.
Thank you very much, Commissioner Benham. Commissioner Stump.
Thank you, Mr. Chairman. I don't have any formal remarks and I don't have any questions. I would like to just make a comment relative to the term deference. As everyone else was talking, I was thinking deference seems almost too simple a word to describe the process involved in getting us to where we are today. So we at the Commission and all of the staff have worked tirelessly with our international counterparts to arrive at common standards and a common understanding and a common respect for one another. And I think much credit is due to many people at the agency, including the chairman and my fellow commissioners, as well as numerous staff that I can't call by name right now, but I just want to thank you all for working collaboratively in the Commission and with our colleagues around the world. Again, as I said before, I emphatically reject the notion that deference to international regulatory authorities who have comparable regulations weakens our oversight or the protection of our markets. I really do believe that this is the best thing for the market and that coordinated regulation around the globe was what was intended coming out of the financial crisis. So with that, I will name one person, Roger. I came to know you when I first arrived at the Commission. The first rule I worked on was a rule that you were involved in, and I always appreciate your attention to detail, and I'm confident that we are in good hands with regard to these determinations. And so thanks to Roger and the DMO team who've worked on this. Thanks so much.
Thank you, Commissioner. I appreciate your kind words.
Thank you very much, Commissioner Stump. Commissioner Berkovitz.
Thank you, Mr. Chairman. I'm also pleased to be able to support these comparability of these findings, and as an example of how international comity and comparability is working. And I've been very supportive of that over the years, and so I'm pleased that the progress has been made in this area. I just have a couple questions. What is, so following up from the other discussion, in terms of transactions executed on these facilities by U.S. market participants, what would be the status of swap reporting, or I guess basically SDR reporting and then real-time reporting for swaps executed on these facilities?
Thank you, Commissioner Berkovitz. So I will note that the original 2017 order makes clear that counterparties that transact on the MTES and OTES listed in the exempt CEF order continue to have to comply with the reporting requirements set forth in parts 43 and 45 of the Commission's regulations.
Thank you, Commissioner Berkovitz.
Thank you, Commissioner Berkovitz. So I will note that the original 2017 order makes clear that counterparties that transact on the MTES and OTES listed in the exempt CEF order continue to have to comply with the reporting requirements set forth in parts 43 and 45 of the Commission's regulations.
So that's both SDR reporting and real-time reporting. They still have to comply with those on the M-test and O-test, correct?
That is correct, yes.
Then the question I had from this morning is we passed the rule regarding the prohibition on name give-up on CEFs. This is a subsequent provision in our regulations. How does that, I guess two questions. One is it covered? You know, what would be the status of a name give up, or is it even an issue on any of these facilities? Are these dealer to dealer, dealer to customer? What, I guess, would it be relevant to those facilities, or is name give up required in any? And what happens when we change our regulations? Well, let me ask it. I'll ask it sequentially. Is name give up an issue on any of these facilities?
Thank you, Commissioner. To my understanding, the EU does not have any ban on post-trade name give up at this time.
So generally, and this may be, I don't know if we faced this question before, and there have been, I think, the comparability determinations that I've been part of since I've been here. I've commented at the time that these are ongoing, should be ongoing processes, and as things evolve, jurisdictions come in, potentially a jurisdiction could go out. How do we accommodate something like this when we've changed our regulation and so that the comparability determination was made prior to that regulatory change?
So, as you know, the standard for these determinations is comparable. It's not identical. So staff has recognized in the past that the requirements in another jurisdiction may not be identical to our requirements in every aspect, but we can, they can nonetheless be found to be comparable for their purposes and effects of the rule. And so that, as you note, this is an ever ongoing, consideration, and it's something that, we would look forward to evaluating in the future. But I would note that, as you point out, post-trade name give up is a recent development, and it's not yet effective. And so our recommendation today to further amend the existing 2017 commission, the 2017 order that was issued by a commission determination should not, in my opinion, add requirements to judge the EU against. But of course, as I mentioned, we would be happy to consider whether that should occur in the future.
Thank you. I appreciate that, and I think that's a reasonable approach at this point in time. We do need stability in these, and you've articulated the current standard, which does not require identical, achieves comparable outcomes. And then what I've said before, I think applies, and I think you alluded to this, Roger, in your answer, that we'll continue to evaluate. We just don't say, comparable, let's everything's fine from now on. I think we evaluate how it's working so far. I think our experience with comparability and the other regimes where we found them to be comparable has been positive. I would note, though, that we should continue to evaluate, and if we were to get information such as Bank of England presented in the Bank of England paper with regard to Euro swaps and potentially dealers moving to other jurisdictions to not be specifically to trade in a manner to avoid CFTC regulation. I think we should be vigilant, and if that should occur, the Commission may need to take appropriate measures. But we're not there at this point, so I'm happy to support the current action, but just keep an eye on future developments. So thank you and the team very much. I know a lot of work went into this, and it's a very positive result. So thank you all for your excellent work on this.
Commissioner, this is Dorothy DeWitt. We want to thank all of the commissioners. I believe there's one more commissioner, please. I injected a little quickly, so kindly continue on, Chairman.
No, there's we only have 5 commissioners. 6 would be very interesting. So you go right ahead.
I was using the new math. I apologize. I just wanted to thank everyone, and we appreciate your comments before and during this meeting, and obviously we'll incorporate them in our approach going forward. Thank you.
Thank you. And again, let me echo on behalf of what all the commissioners had said, thanking the big team that worked on this starting years ago, and all those people that you named, Dorothy, from DMO, from our Office of International Affairs, and everywhere else. Is there any commissioner who is not prepared to vote? Okay, hearing no answer, I would like to ask our Secretary, Mr. Kirkpatrick, to please call the roll for the amendment order exempting certain trading facilities authorized within the European Union from the requirement to register with the CFTC as swap execution facilities.
Thank you, Mr. Chairman. This is the Secretary speaking. The motion now before the Commission is on the approval of the amendment order exempting certain trading facilities authorized within the European Union from the requirement to register with the CFTC as swap execution facilities. Commissioner Berkovitz.
Commissioner Berkovitz votes aye.
Commissioner Berkovitz votes aye. Commissioner Stump.
Commissioner Stump votes aye.
Commissioner Stump votes aye. Commissioner Benham.
Commissioner Benham votes aye.
Commissioner Benham votes aye. Commissioner Quintens.
Commissioner Quintens votes aye.
Commissioner Quintens votes aye. Chairman Tarbert.
Chairman Tarbert votes aye.
Chairman Tarbert votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0.
Thank you very much. The ayes have it, and the amendment order exempting certain trading facilities authorized within the European Union is hereby approved. Before we move on to closing statements, is there any other commission business from my colleagues? Hearing none, I would now like to give my fellow commissioners an opportunity to make closing statements, starting in reverse order of seniority. So we'll go to Commissioner Berkovitz.
Thank you, Mr. Chairman. This has been a very busy month and a couple of extremely busy days. I'm going to be looking forward to catching my breath before we do what looks like a final sprint in September and October on completing a number of other rules on our agenda. And of course, we have the usual press of business. I've been very proud of this agency's dedication and commitment, the commitment of everybody in this agency to advancing our agency's mission through this very difficult time. And although I strongly disagree with the results of 2 of the Commission's actions in the past 2 days, doing 2 300-page plus rulemakings on cross-border and capital, 2 of the most complex, controversial, intricate rules, really, in these circumstances when staff has multiple competing, taking care of family, worried about health, and whatever that we've recognized in entities in the financial markets and given relief for our employees, really put their nose to the grindstone, or whatever you do with the grindstone, I'm not sure, and roll up their sleeves. I'll use that metaphor. And I really want to thank the staff for all that work and the work they continue to do. I would say also, Mr. Chairman, I appreciate the manner in which you have conducted these meetings, where you have given every member of the Commission an opportunity to state their views. I think it's healthy, and I think it's healthy when we state our views openly and honestly, and other members of the commission are free to agree or disagree with those. I think it's good that the public hears that discussion and sees the disagreements. That's why we have a 5-member commission, to get those diversity viewpoints. And at certain times we agree, and at certain times we disagree. And I think we've seen today an example of how we can do both. We can disagree, and then we moved on to business where we can agree. And we will continue to do just that. We will continue to work on these matters, and each of us takes our own judgment as to what's in the best public interest and articulates those. And I thank you for conducting the meetings and the commission's business, which enables us to do just that, whether or not you may agree with any of the individual views we expressed. But open dialogue and consideration of our views, consideration of the public comments is transparency in the agency is absolutely critical. So I thank you for that, and I thank my colleagues as well for the robust discussion. We will have more of this. And I thank the CFTC staff. I thank my staff. And I look forward to further, I thank the public for their comments and their input on these, and I look forward to a break and then resuming after August. So thank you very much.
Thank you very much, Commissioner Berkovitz. Commissioner Stump.
Thank you, Mr. Chairman. Except for the part where he vehemently disagreed with the outcome of some of the rules, I'd like to second everything Commissioner Berkovitz said. He's right. I think it's a real benefit to be able to work on a 5-person commission with very different viewpoints. It actually helps us arrive at a better product. And well, in the end, sometimes we simply have to vote. We cannot negotiate forever. We have to arrive at the point at which it's time to make decisions, and those decisions are sometimes very difficult. But the reality is that I have confidence that each and every one of my colleagues has invested the time and energy in trying to make the product the best it can be. So I'm very grateful for that opportunity, and I'm proud to work with the 4 gentlemen that I'm able to work with on this particular commission. Thank you.
Thank you, Commissioner Stump. Commissioner Benham.
Thanks, Mr. Chairman. Not much else to add besides what's been said. Certainly appreciate all the work of the staff over the past few months, particularly the past few days. Obviously, it's been a busy couple of days with major rules. Appreciate all the work, as I've said before, and appreciate my colleagues' points of view, and I look forward to continued respectful dialogue among all of us. As I said most recently, our rules are not stagnant by any means or by any stretch, and we have to continually observe and be vigilant of markets as they change, evolve in all parts of the world. So look forward to future conversations and debates with all of my colleagues, including you, Mr. Chairman, so that we can continue to get better on a daily basis. So thanks, Mr. Chairman, for your leadership on all these things. Certainly look forward to a few weeks off. I know we have not too much on the schedule in the near future, but as Commissioner Berkovitz pointed out, we have we'll pick up in September and October, and looking forward to that with some new and fresh energy. I do want to, before I wrap up, and I try to do this every time, but I just want to thank my staff. Casey McLaren, who's the legal intern with me this summer, unique situation for interns, certainly, but she's been a great help in the past month or so, and I hope she's enjoying the experience. David Gillers, my chief of staff, who's been with me for about a year now, and has just been incredible, picking up on all matters and just being a great leader in my office. John Dumphy, who's my lawyer, and he's fantastic, and I appreciate all the work that he's been doing for me on enforcement matters, but rulemaking as well. And then Laura Gardy, who helps me with my speeches and all matters DSIO and anything else that she has time to do, which she always makes time. It's been an interesting and obviously challenging 6 months for all of us at the Commission. And I want to recognize, obviously, again, the staff for their work. But as I kind of reflect on my life, personal at home and then work, it's been hard. And I just want to point again out to my staff who just made my life easier. Couldn't have couldn't do it without them, and they haven't taken a break once, and they've just kind of pushed through, and it means a tremendous amount to me, because as we're all dealing with things at home, in the workplace, we're trying to endure and keep doing our jobs well. So just want to take an extra minute to recognize them. But thanks again, Mr. Chairman, and thanks to my colleagues. Look forward to getting back at it in September. Thanks.
Thank you very much, Commissioner Benham. Commissioner Quintens.
Thank you, Mr. Chairman. This is Commissioner Quintens. Those really eloquent comments that we heard from Commissioner Benham, I'd like to reiterate those and acknowledge within them my own staff, as I'm sure all the other commissioners would do if they got to follow those remarks. Kevin Webb, my very dedicated chief of staff, Margot Bailey, my brilliant counsel, Peter Calls, who has worked tirelessly to go through the complicated web that is the cross-border rules and has such a deep knowledge of the intricacies of the CEA, particularly with regard to clearing and the cross-border activity that this rule today applies to. I just would really like to thank them for all of the work in what is a challenging environment to sometimes stay focused and stick to the task at hand, communicate to get questions answered, and they've just done a spectacular job. I'd like to thank you again, Mr. Chairman, for the leadership on these issues and the staff. I would like to also acknowledge the beneficial nature, I think, of today's dialogue. I was pleased to engage with and respond to and listen to the arguments and views presented of my colleagues, whom I deeply respect and value as equals at the Commission. And I think while we disagreed on the outcome of one of today's rules, I think the dialogue laid our beliefs in plain view, which I think is the reason to have open meetings and is the reason for the Sunshine Act to actually exist and for us to follow. So thanks for all the work that went into today. I appreciate the time. Thank you, Mr. Chairman.
Thank you very much, Commissioner Quintens, and also to Commissioner Benham, Stump, and Berkovitz. Let me echo many of your comments regarding, the way that we work together as a commission, and we disagree, but we're not necessarily disagreeable. It is, in fact, the saying that you put your nose to the grindstone, and it reminded me of Zig Ziglar, the motivational speaker, who I think says life is like a grindstone in that it'll either grind you down or polish you up. And I think working with all of you over the last several months, particularly in the midst of the coronavirus pandemic, and working on rules that, quite frankly, are some of the hardest, thorniest, most challenging pieces left from the Dodd-Frank Act, recognizing all of the things our predecessors actually worked on as well that led to the last couple of days and some of the other things we're working on. These are really tough, and all of us often come at these with actually differing views. So even among those who supported the rule today, there were sort of, in some cases, differing rationales, and the same was true with those that didn't support it. Again, these are some of the toughest issues, but I think as a commission, we're not going to dodge them. We're going to work on them and work hard on them. And that, of course, brings us to our staff. Our staff has been incredibly resilient during this period, really rising to the occasion, given everything else that's going on with issues at home and dealing with the coronavirus and its impact on our daily lives. I especially want to thank for my own staff, Chelsea Pizzola and Matt Dagler for their work on the cross-border rule, and also Dan Grimm for his work on yesterday's capital rule. As you mentioned, the commission itself will be getting a little bit of time off, in the sense that we will be not having another open meeting until September. But the CFTC staff will not necessarily get a lot of time off on the summer, because I will be working with them to get the final rules in good shape, so they can be sent to the commission later this summer, so we can do things. So I do want to recognize the critical ongoing work of our staff. many of whom will not be able to take a break until the fall. But with that, I just again want to thank everybody, and also for the public for joining and listening in to us today and every day. We do this work for you and for the American people, and we say the Pledge of Allegiance in the very beginning to remind us of that. So there being no further business, I would entertain a motion to adjourn our meeting, reconvening, of course, at some point for a new meeting in September.
So moved.
Second.
Thank you. Those in favor of adjourning the meeting will say aye.
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 Those opposed, no. The ayes have it, and once again, I'm very grateful to the CFTC staff for their excellent work. This meeting is hereby adjourned. Thank you.